collaboration between BITS Law School and PanScience Innovations that stands at the forefront of legal professions transformation through AI and emerging technologies. The Pallet Center was conceived with a clear and an urgent purpose to empower legal professionals, judicial officers, students, and institutions with tools and training necessary to adapt to the world where AI is no longer optional but is essential. As the legal world is confronted by rapid change, we must ask how can we retain our ethical foundations while evolving our tools? How do we enhance judiciary delivery without compromising fairness or privacy? And how do we prepare the next generation of lawyers to thrive in technology-driven world? These are the questions that Pallet Center seeks to address, and today's event is a powerful beginning. May I now request Honorable Justice D.Y. Chandrachud, Shri R. Venkatramani, Attorney General of India, Dr. Anshul Pandey, Founder PanScience Innovation, Dr. Ashish Bharadwaj, Dean BITS Law School, to kindly come to the stage for lighting of diya. I'm honored to welcome Dr. Anshul V. Pandey, founder of PanScience Innovations, to deliver the inaugural address. Dr. Pandey is an alumnus of BITS Pilani and NYU, and a serial innovator who's launched more than 16 deep tech innovations. His company, PanScience Innovation, is India's largest AI startup studio. He's also a visionary behind Nyaay AI, an empowered platform transforming how we access and analyze judicial data. Dr. Pandey's work sits at the cutting edge of what we call intelligent justice, where AI tools support decision-making, automate documentation, and improve research accuracy across courts and law firms alike. May I now invite Dr. Anshul Pandey to the stage to deliver the inaugural address.
Right. Thank you everyone for having me here. What a fantastic morning. It's what makes this morning even more interesting is because at around 2 a.m. my wife woke me up. She said, "Hey, there is a storm." And the first thought I get is, okay, where is my daughter? Second thought I get, okay, what's gonna happen to the event tomorrow? So thankfully, we are all sorted, we are all good. Without further ado, thank you all for coming here. Very good morning, everyone. Honorable Dr. Chief Justice, former Chief Justice of India, D.Y. Chandrachud, Honorable Shri R. Venkatramani ji, leaders from BITS Pilani, and Pvt Law School. Distinguished guests, friends, thank you all for coming here. Today is a special day for us, for all of us here. It's not just a day where we are launching a center. It's a day where it's a meeting point of many journeys. A journey that combines technology and law, a journey that combines academia and industry. So welcome all to the inauguration of our Pallet Center. And over the next 10, 12 minutes, we're going to talk about what this journey has been for all of us. What has transpired over the last 2.5 years? What have we been building over the last 2.5 years in a very relentless manner? So let me start with a small story, the story of my own journey. A few years ago, during Diwali visit, like every NRI person does, right? They come to India for a Diwali visit or a Holi visit. I just happened to be visiting a district court in India, in a very small town, my hometown. In one of the chambers, I watched as a very senior advocate was sitting surrounded by mountains of files, and literally mountains of files. Clerks were combing through judgments with highlighters and thread-bound folders. Very, very real India, right? And then again, carefully putting slips on specific nazirs or precedents, and also tying them back with those cotton threads. That senior advocate is no one else but my father, who's here, and who has been very inspirational in putting us back in this journey of bringing technology to law. One of his junior lawyers had already spent 3 hours trying to look for a specific nazir, and not because it was very obscure, but because it was buried. And I remember just thinking, and at that time I was doing some interesting stuff back in New York. I remember thinking, we have AI that can analyze thousands of documents, like literally millions of pages in seconds, and it can find that specific precedent very quickly. So how come no one is really doing it? And it wasn't really inefficiency. It was a gap between the two worlds. One world in Manhattan, where I was living, my then home, which was running on algorithms and real-time search. The other world, my real home, was still flipping pages and dusting files. You see, for years, I led a company that was building powerful AI tools. The company was building systems that could mine through financial documents and legal contracts. We were helping Fortune 500 companies and ultra-rich become richer. I'll take that a bit of a pause and still like reflect on it. And at NYU, during my PhD tenure, as a PhD researcher and later as a faculty in AI, I also worked very closely with NYU Law. And there I worked very alongside some of these prominent professors to really look at how AI and data science can be adopted by legal professionals, lawmakers, as well as policymakers in better decision making. And then I brought the same thinking to United Nations and several global NGOs, where I deployed AI tools in some very critical processes where trust, fairness, and the failure and the success had real consequences. So why am I telling you all of this? It's because when I stand here today talking about this Pallet Center, the journey didn't just start like a couple of months ago. It was embedded since my childhood. There were ideas and thoughts and dreams and experiences that were all combing together to this particular moment. So that moment didn't start a company, right? That realization didn't start a company, it started a mission for me. That mission made me pack my bags and move back to my home. Not out of nostalgia, to be very honest, but with purpose. And for last 2.5 years, we have been relentless to pursue that purpose. That purpose is today what's called PanScience Innovations, which, as has been shared a few times, is now India's largest AI and deep tech startup studio. At PanScience Innovations, we call it PSI. There is a technical jargon associated. PSI is pressure per square inch. So we can take a lot of pressure and operate under a lot of pressure. PSI is also psi in Greek symbol of Schrodinger's wave equation. So we want to go to the nitty-gritties and the quantum level of every experience and every technology that we build. But when we build it, we said, okay, what if AI didn't just automate? Could it make lives better? And that is where, not in one domain, but across various domains, you see we have several ventures. Today, as I stand here, PSI has 16 plus ventures in finance, education, defense, infrastructure, healthcare, life sciences, and more. And each one of them have a treasure trove of inspiration and story to tell. But of all those ventures that we built at PSI, the one that has brought all of us together is also the one that started this journey, is what we call as Nyaay AI. We call it Nyaay AI because its mission is simple and sacred: justice. That's all, plain simple. How we go about doing it has layers to it, but we'll talk about it. But it will not be possible to talk about Nyaay journey without mentioning the 2022, the small talk I gave at the Constitution Day at the Supreme Court of India. That talk, since that talk till today, about 2.5 years has passed. We have worked hand in hand with the judges, clerks, lawyers, scholars, not to automate legal processes, but to rebuild it with trust at its core. And it wasn't just in India. We now have deployments even outside of India. When we deployed our systems, AI systems at Supreme Court of Singapore, there was a lot that we learned about the facets of trust. So I'll talk briefly about trust aspect. Trust for us is basically a five-factor or five-principle journey. First, contextual understanding. India is wide, vast, and there are nuances in every legalese. So AI must understand nuance, not just keywords. It cannot be keyword matching. It cannot be you go on an online database portal and you search 5 words with a Boolean operator in between and you believe that the right precedent will just pop up. It just would not. Second, privacy and security. Legal data is sacred for us. Whatever system we deploy cannot be a Trojan horse. It has to act as the guardian at the gate. Third is the regional language support. India is vast, as I said, so we wanted to make justice accessible for all. Fourth is data localization and sovereignty. And this is something that I believe is going to become very fundamental component in every AI system that we use, even as law firms, which is every data must be stored and processed within India. It's essentially a factor that cannot have a compromise. And I can talk about like the longer repercussions of it. And fifth is the responsible and ethical design, not in implementation, but the design. So fair, transparent, and accountable from day one. No black boxes. Every recommendation that the AI system is giving, it must be able to provide rationale. No shortcuts there. And all of these things that I'm mentioning, you can actually see them encapsulated in everything that we would do at the Pallet Center. So trust, as I said, wasn't a feature for us. It was a foundation. It was the founding pillar on top of which we wanted to build this ecosystem of trust, which is why we wanted to build this Pallet Center. Now, it was not a project. It was a necessity. It was a need of the hour. And it was a place that we wanted to create where we could bring these principles, these learnings, these technology innovations, these collaborations to life. But we did a very smart thing. We collaborated with BITS Pilani. So, because again, in the journey of trust, we didn't want to build it alone. And in BITS Pilani and BITS Law School, we found the perfect partners who are not only bringing intellectual capability, but also moral clarity with regards to what we really wanted to do. In none of our conversations from day one till now, we talked about, hey, how is it going to, generate revenue in long term? We said, okay, how is it going to really impact? How is it going to be the center for everyone? It was never about, is it going to be the center for BITS Pilani? It was about, can it be the center for India? Can it be the center for the world? Where we talk about innovation in legal systems. Now, of course, you might be wondering why we call it a palette center. Because like an artist's palette, it's where colors come together to create something new, something bigger than the colors themselves. On their own, colors are beautiful. But when you combine them together with intent and imagination, that's where magic happens. At Pallet, our colors are technology, law, data, ethics, and education. And our canvas, the legal system. We are not here to paint over it, and that's something we have been very clear from day one. Even when we talk about AI, we talk about it as augmented intelligence, not an artificial intelligence. It must supercharge and superpower the users. So we wanted to blend these elements into the system by the design to make them faster, smarter, and fairer, and above all, more human. So let me show you what that looks like once it's implemented. A woman in rural Maharashtra faces domestic abuse. She picks up her phone and speaks in Marathi. An AI assistant on the other side helps her understand her rights, draft of a petition, schedules some meetings. Instantly, her lawyer sitting somewhere in Mumbai receives a brief with a translated precedent and a summary of her case. Now picture this. If it was a mid-sized law firm in Bhopal, the clerks who are buried with case files and manually searching through precedents, like my father's team has been doing, drafting contracts, fixing templates, typing out summaries, or looking for the translator who could translate a document line by line. With Pallet's AI tools, that would change. Precedents would be surfacing instantly. Judgment summarizations will happen in plain language. Drafts will be prepared in minutes, not days. And a clerk who'd spent hours tying files with cotton threads can now spend time reviewing insights and preparing drafts. In the court, the staff wouldn't have to shuffle papers. They will verify documents and prepare hearings through AI tools. And when it's time, the judge would open a tablet with the facts presented in front of them, highlighting key rulings, and more importantly, with the footnote, why this particular recommendation matters and what's the precedent and premise behind it. So this is not really a promise. This is not a someday promise. It's something that's happening right now at the Pallet Center. A lot of what I have spoken about is already deployed, and you'll be seeing it in one of the demos that we'll do today. We are in version 3 of Nyaay AI product, and I think we'll talk about it. So we are not, as I said, we are not really upgrading the legal system per se. We are trying to reimagine it with technology at its core. And lastly, none of this would have been possible without the pioneers who lit the path for us. And one of them is with us today. Dr. Justice Nyaay Chandrachud, the former Chief Justice of India. He didn't just talk about change. He made it happen. And I have been witnessing it from the sidelines and in some capacity engaging with him once in a while to learn in the process, whether it's live court transcription, translation of judgments, or trying an attempt to deploy AI in the case management systems. And above all, a belief that technology must serve justice, not replace it. His vision is a cornerstone of what we are building at Pallet. Sir, your presence today reminds us that tradition and technology can walk hand in hand. So thank you so much for coming here. To everyone here, lawyers, technologists, students, this is also your movement. Pallet is more than just a center. It's a platform. It's a promise. An era where a clerk in a remote village will have access to the same tools as a large law firm in Mumbai, where courts will run smarter and justice will remain human. This is a bold vision, but with the minds and hearts gathered here, I believe we can build it. So let's pick up this palette. Let's paint a legal system worthy of our future, one brushstroke at a time. Thank you so much.
Thank you, Dr. Pandey, for those inspiring words. I now invite Professor Dr. Ashish Bharadwaj, Dean of Pvt Law School, for the presidential address. Dr. Bhardwaj is a globally respected scholar in law, economics, and intellectual property. As the founding dean of Pitt's Law School, he has led a vision to make legal education interdisciplinary, technology savvy, and socially relevant. Under his leadership, the school has emphasized experiential learning, AI ethics, and innovation in curriculum design, preparing students not just for legal careers, but for legal futures. May I now request Professor Dr. Ashish Bhardwaj to join us on stage for presidential address.
Thank you very much, Simreen. Very good morning to all of you. Dr. Chandrachud, a very distinguished professor of law now, not just justice. Dr. Venkatramani, Attorney General of India. We also have some very, very illustrious people. I see a lot of friends in the audience today. I see Shri Anil Agarwal ji, a proud Bitsian, is a member of Competition Commission. We have Dr. Anshul Pandey with his team. We have faculty members present here. We have Mr. Amar Patnaik, parliamentarian, our friends from General Counsel Association of India, Dr. Prasad, Dr. Panjari Chaudhary. Thank you so much for coming. I'm sure I'm missing out on a lot of names. I also want to start with a story. It may not be as exciting as Anshul's story, but let me start with one. It's a story about with both Sherlock. Then I deduced that there's life on some of them. So I finally deduce that tonight we are not alone. Holmes says, "Watson, you idiot, someone has stolen our tent." Watson's mistake is what we see far too often in everyday life. Our fascination for complexities to get into endless deductions and inferences lead us into paths that kind of astray us and deviate us from what we had initially set out to do. We see that in legal practice, we definitely see that in academia, and dare I say, we see that even in some court systems. And there might be simpler truths to follow rather than relying too much on complexities and complicated deductions. So as Anshul said, in the next 2 hours, you're going to see some of these truths coming out as we unpack what this technology is all about. The legal profession, like many others, witnessed in the past 2.5 years a range of reactive activities. Not proactive, very reactive. In an August gathering like this one, now the term LLM doesn't have one meaning. Now it has 2 meanings. Law schools, and I can tell you from our own experience, amended the honor codes faster than the speed at which students were violating it, because we had to do something. Battle-hardened counsels and litigators, some of them are present here today, grappled with concepts of natural language processing and machine learning, while the younger associates produced fantastic work with the help of generative AI. And suddenly the quality of the work being shared and submitted by young interns from law schools improved in a matter of few weeks. What happened there? The entire billable hour model, which is central to law firms, came under scrutiny as clients started to renegotiate rates on the basis of what all can be achieved by technology, AI in particular. It was unclear whether, at least to me, whether skepticism towards AI of some of the judges around the world was because of hallucinated case law or trying to understand how the counsels were able to pick this new technology so rapidly. Legacy law firms in a protocol-heavy industry were the first ones to move, at least some of them, to move forward in understanding and adopting artificial intelligence and its applications. Ironically, and this is an interesting one, coding experts, programmers, and software engineers continue to work hard over the past 2, 3, 4 years to build AI models that may pose a threat to their own skill sets and jobs. In a nutshell, it's tough not to think of 2025 as the year of artificial intelligence and a lot of song and a lot of dance and a lot of hula baloo around it. We witnessed remarkable technological advancements in our courts, including the profound and very progressive steps and ideas that were implemented by Justice Chandrachud, both in his capacity as a judge and then in his capacity as the Chief Justice of India. However, our legal system, I'm sure all of you will agree, can be made more streamlined, more accessible, more affordable. There are several systemic challenges that confront us today. I'm sure all of us want to see a more user-friendly system of cause lists, a more efficient way to index court documents, and a more reliable method to bunch cases to improve productivity and make an attempt to minimize delays. We desperately need a system of filing and management of cases which is accessible and, as the previous speaker said, transparent and ethical. Data suggests that 769 judges are responsible for clearing a backlog of almost 63 lakh cases pending in the 25 high courts of this country. That's more than 8,000 cases per judge of a high court. In some high courts, the caseload per judge touches 15,000. On top of that, we have only 15 judges per million population. That is 15 judges for 10 lakh Indians. With 5.5 years as the estimated average pendency of a high court case, one can imagine how overworked the judiciary is, how overworked the judges are, and how overwhelming the entire system could be for those who are helping us get to justice. And this is a serious issue. What we are going to do today, as Anshul outlined earlier, is a timely response to an alarming situation confronting us. With Pallet, we are wanting to introduce a structured, methodical, and tested way to apply AI to reshape legal profession, legal education, and the entire justice delivery system. So today, ladies and gentlemen, we mark the beginning of a monumental change. A change in the procedural journey of justice and a change in the protracted journey to justice. I'm delighted to share that BITS, along with PanScience Innovation, are collectively leading this change. A few months ago, BITS Pilani completed 60 glorious years of excellence in science, technology, engineering, innovation, and even social sciences, including law, for the greater good of humanity. What started out as a humble Pathshala 46 years before independence grew into an iconic institution which currently has more than 20,000 students, more than 1,200 faculty members across 5 campuses, and 200,000 alumni. Some of them are sitting in this room today. Over these decades, the science and the STEM disciplines taught us how to build things, how to build magically creative and innovative things. But it was really the blending of technology, public spiritedness, and law and humanities that taught us what to build and why to build it. That's a very important distinction. That's why 2 years ago, we set up a new age, future-ready BITS Law School in Kalyan in Maharashtra. We have committed ourselves to help build a new generation of learners, administrators, leaders, and legal professionals who can dare to dream big and lead the change that India needs, lead the change that our justice delivery system needs. And there couldn't be a more fitting way than to use new technologies like AI to reimagine how law is taught and how it is practiced. One thing is certain, we have moved past what was a period of speculation and into a period of factual and real-world uses of legal AI systems, as Dr. Pandey outlined. The number of law firms, courts, in-house legal teams who need an effective AI-enabled system which is ethical and accessible is growing by the day. Grounded in BITS Pilani's legacy of excellence in science and technology, and BITS Law School's commitment to new age legal education, and PanScience innovations' unparalleled prowess in AI, today we launch a national hub for legal tech which is accessible, efficient, viable, user-friendly, and Indian. The Pallet Center, and Anshul has talked a little bit about it, which stands for Professional Advancement in Law through Executive Training and Technical Education, is a pioneering initiative to drive this change. From predictive analytics to e-filing automation to defect analysis, case bunching, transcription in vernacular, from undertaking dialogues on AI ethics and governance to deployment of Gen AI in law schools for students, from capacity building initiatives to customized training modules, from scalable plug-and-play solutions to custom-built AI-enabled legal tech platforms. That's what Nyaay AI has set out to do. And remember that AI does not and will not replace lawyers. It's an important statement to make in this gathering. AI will not replace lawyers. One of our panels is focused on this particular theme. But it will make beginners a bit uneasy. And I feel that it may hit the deniers a bit harder than others. Through a palette of solutions, we begin the process of change to make our court systems more efficient, our law practice more productive, our legal education more ready for the future, and our justice delivery more reliable and predictable. We have imagined a different system. In fact, Pallet is that system, and we will bring it to fruition. Long arc of such systemic change bends towards creativity and grit. I'm rephrasing what Martin Luther King said. There is no natural law governing which way this arc will bend, because every generation has to do its own part to bend it. But today marks the beginning of our time of bending the arc of change through a palette of new ideas. And I invite all of you to join us in this journey. Thank you very much.
Thank you, Dean Bharadwaj, for providing a comprehensive overview of our goals and vision with Pallet Center, and for the Sherlock Holmes analogy. It is now our honor to welcome the chief guest for today's launch, Honorable Justice Dhananjay Yashwant Chandrachud, former Chief Justice of India. Justice Chandrachud is a towering figure in the Indian judiciary, known for his progressive judgments, technological foresight, and advocacy for judicial reform. As the CJI, he spearheaded digital transformation in court infrastructure, championed open courtrooms, and emphasized access to justice through digitization. His support for initiatives like Pallet reinforces the belief that AI must be integrated responsibly and ethically into our legal systems, always guided by constitutional values and human dignity. May I now invite Honorable Justice D.Y. Chandrachud to the stage for the Chief Guest Address and Center launch.
Very distinguished Attorney General for India, Mr. R. Venkatramani, Dr. Ashish Bharadwaj, Dean of BITS Law School, Dr. Anshul Pandey, founder PanScience Innovations, and Soumya, Hardik Dave, CEO of Nyaay AI, and distinguished guests who are present here this morning. Honestly, I'm delighted to be a part of this revolutionary launch. And by revolutionary, I do not use the term lightly. I mean transformational in scope and immediate in impact. Revolutionary because it is not just about introducing another piece of technology into the legal landscape. It's about fundamentally reimagining how legal research, practice, and adjudication can evolve with the convergence of artificial intelligence and institutional best practices to build capacity and enable efficient, accessible, and intelligent legal systems. Since this is not a lecture, I will take the next 10 minutes or so to briefly touch upon three postulations. First, accepting reality. AI is here. Coming from the judiciary, 25 years as a judge and over 20 years before that as a lawyer, I would like to first reflect on the digitization of the judicial arm. In our judgment in Sarvesh Mathur versus Registrar General of the Punjab and Haryana High Court, the Supreme Court mandated the provision of virtual and hybrid hearing facilities across all high courts, district courts, and tribunals. Yet when data was collected through affidavits, what emerged was troubling. A consistent pattern of tech aversion, even resistance, not just among court staff, but among the bar. This hesitation over something as basic as video conferencing technology highlights a bigger concern. How do we responsibly integrate emerging technologies like AI into this ecosystem? Because we all should be clear that AI is no longer emerging. AI is here. And I think the only way forward is to take decision-making on technology and its implementation out of the hands of judges and lawyers. I say conscious of the fact that I was chairing the E-Committee for 5 years, and then 2 years as Chief Justice of India when I was leading the technology revolution in the Indian judiciary. But the problem is that it depends too much on single individuals, and how do we then make it as part of our processes and systems? Now that I'm gone from the judiciary, I hear so very often about stories of judges are saying that, well, now that the Chief Justice has left the scene of digitization in the judiciary, we can get back to our paper files. That has to change, and the system can't depend upon either the willingness or unwillingness of a single individual to adopt technology. The judiciary is already, on the positive front, beginning to see AI as part of its operational landscape. We have all seen examples of AI being used in judicial decision-making. In Colombia, a judge used ChatGPT to assist in drafting a judgment involving an insurance claim for an autistic child. In India, the Punjab and Haryana High Court referred to ChatGPT for a broader perspective in a bail matter involving allegations of assault. These instances are no longer speculative. They are real, and they show how AI is becoming a part of the decision-making environment. Similarly, a study by the Center on the Legal Profession at Harvard Law School found that in high-volume litigation cases, particularly in large American law firms dealing with employment or consumer disputes, the use of automated complaint response systems reduced associate time from 16 hours to just 3 to 4 minutes. This freed up resources and allowed human lawyers to focus on strategy, analysis, and client advice. I remember when I began my career in a Wall Street firm, Sullivan and Cromwell, if I was asked what was the nature of my work, I was a little embarrassed to answer, because all that it entailed doing was, quote unquote, pushing papers. But no longer so. As Anshul said, AI is not going to replace human beings. It's going to free up time for real, creative work which experienced professionals have to discharge. But these examples demonstrate the practical benefits AI can offer. But they also raise fundamental questions about the limits of AI's role in legal decision making. And my second postulation, therefore, is AI is here to augment, not to replace. There are cases where AI clearly cannot replace human judgment. For example, in the Secretary Ministry of Defense versus Babita Punia, a judgment which I scribed just before the COVID-19 pandemic, the Supreme Court ruled that female officers must be granted equal opportunities for permanent commissions in the Indian Army, and then in the Indian Air Force and the Indian Navy. That's how you see women at the borders commanding platoons of male and female colleagues. You see them as Air Force pilots carrying out a mission and returning home safely aboard a Rafale fighter. Or you see them in naval submarines now. Now, this decision was not merely a straightforward application of military regulations. It required the court to grapple with deeply entrenched gender biases, societal norms, and evolving principles of equality and dignity under the Constitution. This highlights that while AI can assist with routine or data-driven tasks, it cannot but replace the nuanced understanding and empathy that human judges bring to complex social issues. Or just the week that I retired, we had a young student with an 88% disability who was denied admission to a medical college. AI would have answered possibly by saying that the rules are all against that student. But we said rules or no rules, this student has to be admitted to medical school. Because if that student suffers from 88% disability, it's for us as human beings to make those reasonable accommodations for him or her to succeed. Yuval Noah Harari captures the nuance of AI's power and risks very well. In his book, 21 Lessons for the 21st Century, he describes how algorithms, when trained on vast amounts of personal data, could begin to understand us better than we understand ourselves. I always believe that my spouse understands me much better than I understand myself, and likewise, me understanding my spouse better than she understands herself. I'm not sure she agrees with the latter part, though. These systems might influence our decisions on what to buy, how we vote, and for the youngsters, even whom to date. But more worryingly, if applied without checks and systems like the judiciary, they could shape outcomes that deeply affect lives. Harari reminds us that the threat is not that algorithms will become evil, but that we might begin to trust them blindly. That kind of uncritical dependence is something we must avoid. And that's what we are taught intrinsically as judges and lawyers. Never believe what you see or read. What is apparent may not be real. At the same time, responsible use of AI remains a major concern. Not all users of AI in legal systems have been responsible. A year ago, a federal judge in Manhattan fined a lawyer $5,000 for filing a brief that contained fictitious case law generated by ChatGPT. Cases such as Verghese versus China Southern Airlines and Shaboon versus Egyptair did not exist at all. They were fabricated by the AI and included without verification in a personal injury suit involving Avianca Airlines. This example is not just about shortcomings of AI alone. It's about the absence of organizational policy, the lack of review mechanisms, and the failure to uphold professional responsibility. When I was studying law at the Campus Law Center in Delhi University, years and years ago, we had this fellow colleague. There was a Hindu law question in the Hindu law family law paper. So we asked him, "Bhai, kya likha?" So he said, "I wrote that the answer was in the judgment of the Supreme Court in the Bombay High Court," he said, I think, in Arjun versus Bhima. So we asked him, "What is Arjun versus Bhima?" He says, "I don't know." So we said, "But where did you get this judgment?" He says, "You presume that the examiner will know that there is no such judgment." So human beings did that before AI, and they'll continue to do that after AI as well. So it's not something which is peculiar to AI, it's peculiar to the human mind. This leads us to the crucial role of governance around AI use. firms, institutions, and individuals must implement clear policies for using AI responsibly. These include internal guidelines for verification, secure handling of client data, compliance with data protection laws, and routine human oversight. And my third and final postulation, the concept of responsible AI. This is where the concept of responsible AI becomes important. Professor Virginia Dignam from the Delft Design for Values Institute explains, AI systems are not responsible in themselves. Responsibility lies with the humans who develop, deploy, and apply them. So they lie with Anshul and his team. Responsible use of AI requires us to act on two key priorities. Firstly, capacity building, and that's what Pallet is designed to deal with. This center is fundamentally about empowering the legal ecosystem by building core competencies in artificial intelligence, data science, emerging technologies, and ethical standards. It is about preparing tomorrow's legal professionals to not just coexist with AI, but to work intelligently alongside it. And that's why this partnership with BITS is so crucial, because it's not just about technology. It's not just about law. It's about creating new colors from this palette, which goes beyond technology and law while synthesizing the two. I remember that in last year's remarks at the Indo-Singapore Judicial Tech Conference, it was really a cutting-edge conference, Dr. Anshul Pandey from PanScience Innovations was also a panelist. There was considerable emphasis on legal education and the need to reimagine capacity building. I recall Dr. Dirk Harting from the Singapore judiciary stressing the importance of developing the T-shaped lawyer, T as in technology. A lawyer with deep domain expertise in a particular field of law, which forms the vertical stroke of the T, along with a broad understanding of related disciplines such as technology, data science, programming, and ethics, which form the horizontal stroke of the T. This is no longer optional. It is a need of the hour. Lawyers today must not only interpret statutes, but also understand how AI systems arrive at their recommendations. Just yesterday, I asked a young intern who was assisting me to give me a research note on conflict of interest in financial markets. In less than 2 hours, she was ready with an 8-page note. And the first message which I sent her on my WhatsApp chat was, I hope this was not driven by AI or Meta. She did it on her own. Brilliant student. So lawyers must today not only interpret statutes, but also understand how AI systems arrive at their recommendations. This includes knowing what data is being used, what assumptions are built into algorithms, and how to critically evaluate or challenge their outputs when necessary. Without this foundational understanding, lawyers risk either over-relying on these systems or rejecting them outright due to the fear or skepticism of their use. Bridging this knowledge gap requires a fundamental mindset shift in how we approach education and professional development, not just for students, but across the legal profession and allied fields. We must all engage with concepts of digital literacy, algorithmic accountability, and ethical reasoning. Secondly, industry and stakeholder collaboration in AI is equally important. Pallet itself is an example of such collaboration between BITS Law School and PanScience Innovations. What is heartening today is to see the kind of representation this event has brought together. When we speak of the legal community, we often limit our thinking to judges, lawyers, and courts. But we must expand that definition to include legal technologists, researchers, academic leaders, law students, policymakers, in-house counsel, design thinkers, and even those working on legal aid and access to justice. During my time as chairperson of the E-Committee of the Supreme Court, I saw firsthand the importance of this collaborative mindset. Phase 3 of the E-Courts project, which eventually led to a budget of over 7,000 crores being sanctioned by the Government of India, was the result of collaboration between civil society, the Indian judiciary, and technology and domain experts outside the judicial system. When I asked Dr. Anshul Pandey to come and work on AI for the Indian judiciary, I was fascinated because they spent close to a year and a half understanding the Indian legal system. And the end of that year and a half, when they had designed their first module, I remember what he said to me. He says, you know, we have designed modules across the spectrum, but I've never found anything as complex as the Supreme Court's procedural requirements. So you have to, as technologists, step into our shoes. But equally, as administrators, we have to get off our shoes and allow them to get into our shoes. Too often we think in the Indian judiciary that we know everything. We honestly don't. And it's time that we allow these decision-making processes to be taken away from us and to be vested in experts who count. I have seen firsthand the importance of this collaborative mindset. We have worked not just with judges and registry staff, but also with the National Informatics Center engineers, law school faculty. We had an MOU with IIT Madras and private developers. This cross-pollination was essential to design digital systems that were functional, scalable, and rooted in ground realities. But we must also acknowledge that technology alone does not solve all problems. AI assistance in routine tasks such as summarizing of cases, organizing evidence, or drafting responses is well known. AI assistance in routine tasks such as these and other aspects will really enable us to devote adequate productive time as young lawyers and senior professionals, both. But what AI can truly achieve beyond the repetitive is a question that can only be answered through collaboration, through seminars and conferences and interdisciplinary dialogue and continuous knowledge sharing. This is not just a national issue. Even internationally, there is a growing momentum to frame ethical and legal standards around AI in justice systems. For instance, the European Commission has adopted guidelines for the ethical use of AI in the judiciary, emphasizing transparency, explainability, and non-discrimination. It is encouraging that Pallet actively promotes collaboration, recognizing that sharing knowledge and best practices across borders is essential for developing responsible and effective AI frameworks in justice. I've been reading a book, in conclusion, let me say this. I've been reading a book by Richard and Daniel Susskind on the future of the professions. And they made a point which I must share with you as I conclude. In a print-based industrial society, the professions played a central role in the sharing of expertise. In a technology-based internet society, increasingly, capable machines operating on their own with non-specialist users will take on many of the tasks that have historically been the preserve of the professions. And therefore, as we conclude, let me just throw up some questions. Are courts places or are they services? Do people really need to converge in physical spaces to resolve disputes? We've already implemented virtual courts in the Indian judiciary, vulnerable witness deposition centers, where a victim of child sexual abuse or a woman of gender violence who has been subject to gender violence doesn't have to be in the courtroom to confront the aggressor, or online dispute resolution. We have spoken about post-colonial societies. When I was graduating from St. Stephen's, we spoke about the challenges of a post-colonial society. 2 years ago, we spoke about the post-truth world, where truth itself is what you manufacture. There is no objective truth. We are now moving to a post-professional society, which will require digitization of the professions, the routinization of professional work, and the demystification of professionals. How we use technology in our professions is in our hands. And I'll only conclude with what a very distinguished writer by the name of Anthony Kenny said in a book called What I Believe in 2006. Technology, he said, puts the sins of omission as immediately and inevitably within our power as it puts sins of commission. But I think these are unique ventures, which are now being pursued, and they are a sign of changing India. And I hope that they will be a forerunner of a changing legal profession. The legal profession all over the world is hopelessly behind its times. Judicial systems are horribly behind times. And I think it's innovations like this which can aspire to make our legal systems more in sync with the times, and the judicial system less of a laggard and more of a forerunner for change. So I thank both Anshul and Dr. Ashish Bhardwaj and the entire team for putting this together, and present you with my best wishes for your success. Thank you very much.
Thank you, Justice Chandrachud. Your insights are not only informative but deeply motivating. May I once again invite Honorable Justice D.Y. Chandrachud to the stage for unveiling of Pallet Center's logo.
Are you ready for the photographic moment?
Across the legal world, one thing is clear. The future will be powered by AI and emerging technology. India's legal community is poised to evolve, not by replacing tradition, but by enhancing it with innovation. And leading this transformation will be the Pallet Center, a one-of-a-kind initiative by BITS Law School and PanScience Innovations. Set in Mumbai, the center will bring together the best of law, AI, technology, and education to build new capabilities across the legal ecosystem. The center will introduce impactful AI-powered solutions developed by ventures like Nyaay AI, designed to enhance legal research, optimize court productivity, and support ethical adoption of AI tools. These technologies will not replace the legal process. They will strengthen it. Through executive education programs, workshops, and AI solutions, Pallet will equip law firms, general counsels, courtroom personnel, advocates, researchers, and students with the skills to navigate an AI tech-enabled legal environment. The center will also foster global and national collaboration on emerging technologies, working with industry leaders, eminent jurists, law firms, technologists, policymakers, and academic institutions to co-create standards and solutions. The Pallet Center will become a platform for dialogue, development, and delivery of future-ready legal innovation. Anchored by the academic excellence of BITS Pilani, driven by the forward-looking vision of BITS Law School, powered by the deep tech AI expertise of PanScience Innovations, and India's legal AI assistant, Nyaay AI, the Pallet Center will be a catalyst for transformation, enhancing legal systems, enriching education, and enabling intelligent innovation. And it will all begin right here. Introducing the Pallet Center, where law meets innovation.
May I kindly request all our esteemed guests and panelists to join us on stage for a group photo. Also the panelists, please. Yeah, please. To showcase the real-world impact of AI in law, we now move to a live demonstration by Mr. Hardik Dave, CEO of Nyaay AI, a venture of PanScience Innovation. Mr. Dave leads the development of tools that summarize judgments, classify documents, and optimize court workflows, all driven by responsible and secure AI. Today, he'll walk us through these tools that can support judges, lawyers, and law students alike, making legal work more efficient and data-driven. May I now invite Mr. Hardik Dave to stage for the AI in action demonstration.
Good morning, everyone. It's indeed a pleasure for me to be here and showcase the kind of efforts we have been putting in for the last 2 years in developing the tools that we have been talking for almost like 1 hour. Honorable Retired Chief Justice Shri D.Y. Chandrachud sir and distinguished Attorney General of India and the respected dignitaries present in the hall and those joining us virtually. In my session today for the next 15 minutes, I'll be taking you through the tools that we have been building. Nyaay AI, as we mentioned, my previous speaker, Mr. Pandey, also mentioned, at the core of everything that we do, there are 3 fundamental pillars that we have been aiming at. That the solutions that we build has to be purpose-built for legal context. They have to be aware of the context, which laws, what problem statements they are being built for, and then they have to be compliant with the privacy law requirements that we have. And it has to cater to the requirements of each type of legal stakeholders, from the law firms to the researchers, legal teams, as well as the judges and court staffs, and most especially the litigants. And when I say litigants, it includes both sides, the individuals and corporate litigants, which has the problem of usually, say, legal literacy, as well as government as a litigant, which usually faces huge workload at the departmental level. And then we have been talking to several state governments and various attorneys all across who says that how difficult the problem it is for them to manage the workload that they have and how AI can come to help them. These 6 pillars, Mr. Pandey also covered in terms of what are the design principles that we keep in mind when we start developing the solutions. The first point, it has to be purpose-built for law. Any generic AI solutions such as ChatGPT or other tools which are available in the market, they have never been specifically trained to solve a legal problem. And that is why they would never serve the problem statement in the perfect way. The second, that just fine-tuning it for the legal context is also not going to solve the problem in a complete way. It has to be contextualized with your enterprise data. So if you are a law firm, if you are, say, an institute, the strategic mode that you have is your data, your practices, your knowledge repositories that you have built over the decades of practice. So if the AI is not exposed to that knowledge repositories, it would never be able to make a difference that you would ideally want for. The third is it has to have comprehensive capabilities, capabilities not just to draft the document, but also to provide insightful advices in terms of what is right and wrong. It has to be privacy compliant. And when I say privacy compliance, what I would request that everybody, I'm sure everybody present in this hall is using some of the other AI tools today for some type of task. I would request that you go through the terms of usage of that particular portal that you're using, and most likely you're going to find that the policies very clearly states that the data resides with the United States or China or other countries, wherever these tools are operating from. And then if there is any legal complaints, any proceedings that you have to take, you would have limited options. So a tool which is built for India needs to abide by the law of the land. And therefore, those sort of deployments, any tool that you use needs to provide the flexible options of the deployments when it comes to the solution deployments. The last 2 points, number one is it has to take care of hallucination requirements. There has to be a mechanism to check how AI is generating a certain output. And last but not the least on this pillar is law is an evolving field, and there has to be continuous feedback loop which takes care of those amendments which are coming into the laws, and then there is a scope for continuous improvements. Keeping these 6 principles in mind is where we build Nyaay. As you see layer by layer, the bottommost layer is the flexible cloud deployment options. So the solutions that we build is not necessary that you use it on our cloud, because we understand that, for example, when we do deployments in judiciary, there is huge concerns about the ability to process undecided cases and the concerns around sharing that on the public cloud. In the similar way, when we work with, so we are working with, say, a Middle East based, a very large consulting firm having practice in corporate and taxation laws. And then they had this concern that over the last 30-40 years of our practice, we have built that moat with the knowledge repositories. And if you share that, what if you are going to share the same model with other law firm? How do we create this advantage for us? So that is why we provide that flexibility, that the data that we use for your problem statement is not going to get shared with any other law firm or any other organizations. So the first layer is the ability to deploy the solutions wherever you would like to be. And on top of it is what resides a Nyaay AI engine. So this Nyaay AI engine is a fine-tuned legal AI solutions with over 1 billion tokens from the legal context. This comprises of the law repositories, of historical judgments from the Indian courts, Supreme Court, various high courts over last many decades, as well as all the public domain repositories which are available. And then on top of that, Nyaay AI engine. So Nyaay AI engine in itself is much more capable as compared to any other generic AI solutions to solve a legal problem. But then the real magic happens when you connect this engine to your enterprise data, and so that it get contextualized and personalized for your specific problem statement, the way you like to draft a document, the way you would provide maybe an advisory note. So all of that, and then on top of that enterprise data and the AI engine combined is where we create specific agents to solve a certain problem, whether it is about drafting a very specific document or to do research or to review something, some contract or other documents. Now, with this context, let me quickly jump to showcase some real applications. What you see on the screen today is the version 3 of Nyaay, as my previous speakers also highlighted. We started our journey working with the e-committees of the courts, and that is where our problem statements were largely focused on how do we use AI to automate the e-filing process, how do we identify defects by pre-scrutinize the document at the time of filing itself of the petition and not really waiting for the scrutiny team to manually go through those, and then how do we extract metadata from those newly filed petitions to do a qualitative analysis of what this case entail, and is there a possibility to club together similar cases or maybe do some intelligent triaging. But as this center also focuses on the use cases which are relevant for the larger stakeholders, especially for the private enterprises and the corporate law firms, the use cases that we'll cover is combined for both. So the very first use case that I like to show, the Nyaay GPT model that I talked about, as I said, it's a fine-tuned legal AI model which is already capable enough to take care of most of your questions. And therefore, in this case, what I'll do is a simple example of a query being asked. I think there is some issue with the video still. It's not playing. Yeah. So the first question that I ask this legal AI tool is a very simple question that, okay, what's a writ mandamus, right? And it takes a moment to think through, and then it gives you a very detailed answer of what it is, how does it work, when it is applicable, and the complete context around this. So while this is a very generic, simple example of how it is already able to take care of most of the regular questions that a law student or a researcher or a law firm would have, when connected to enterprise data, you can very specifically ask questions about your own data sets and your own problem statements. In the similar way, the next use case around this is the very popular use case that we see in the real world, the contract reviews, which takes most of the most amount of time for the corporate law firms. So for a contract review use case, in this case, I actually uploaded one of the contract that we have after anonymizing, of course, for Indica, and then I upload the document from here. It takes a few seconds to load that, and then what you see is not just the potential issues being flagged, but also a list of possible recommendations in terms of how do we solve it. So, as you see, the document is now uploaded. It's Indica versus some XYZ vendors based out of Netherlands. It analyzes the contract, and then it goes through a detailed list of issues that have been identified, and then it also categorizes them based on the potential risk which is involved. So the high risk in this case, the jurisdiction was defined as Netherlands, and then there are medium to low risk severity. Below to that, what you would also see that just apart from highlighting the risk which are there, below this it would also tell you that how do we solve it, what are the implications of this particular risk, and then how do we solve this in detail. So this screen, as you see, the governing law in this case was Netherlands, and then you see the implications, and then you also see a recommendation that, okay, instead of, given that one party is in India and the other one is in Netherlands, how about having a neutral venue for, say, arbitration. In the same way, it would take care of every clause, give you the implications, and also the recommendations similar for the IP clauses and the other clauses which are there. And this have been again trained to take care of all types of contracts, right from a very simple NDA to as complex as investment document, SPAs, SHAs getting signed. It takes care of all of those regular contracts which a law firm would have to take care. The next problem statement is usually a law firm or any legal enterprise, and this is also what we really faced a problem when we had to work with the judiciary. They were very hesitant to share some data of undecided cases that we can process for a defect check. So that's where the data anonymizations come into picture. The ability to process, upload a document, and take care of all the PIIs and sensitive information automatically is something which would help them. So in this case, again, upload a simple document. The whole platform is designed to be very simple, but what we would want to highlight is that these are the capabilities, these are the solutions, they fits right into your workflows. So the way you would want to structure them, that solution is available. So in this case, I uploaded a document. You see a list of PII anonymization options. You have the choice, say for an agreement, location might be important. You might not want to anonymize that, whereas some other fields of party information you might want to anonymize. So what it does is upload the document, process it, and then it gives you an original versus anonymized version of the document, which you can very quickly review, and then if everything looks good, it's ready to export in whatever format, whether a document format or a PDF format that you would want. When this is done at a scale, that is what would really revolutionize the next step of the legal AI solutions, right? So as an enterprise, if there are hesitations that how do I share my client data with you, right, or how do I share some confidential data, that concern is also taken care. Or usually in a legal team, the workflows are that one team creates a document, and another team would want that, okay, can you share that file with me? I also want to reuse this. So you can very easily redact all the information which is to be hidden. So in this case, the document is now, say, uploaded. You can preview or download. I click on preview, and then it gives you a pop-up of original and the anonymized document, right? So this was a writ petition document. So the location and all the other information that you see which was sensitive is being highlighted. You'll also see a list of PAN numbers, Aadhaar numbers, which are getting anonymized in this case. So, and another important thing on the anonymization features, whether the PII is in English or across more than 20 Indian languages, as well as all the major international languages, the model have the multi-modal language capabilities, and therefore it is able to anonymize all of that information. Moving on to the next part, one major activity which takes most of the amount of time for any legal team is to generate summaries of huge amount of documents which are being dealt with. So that is where this ready to use module of generating statement of fact and being able to extract timeline from a case comes handy. So what you see now on the screen is a quick summary generator tool. I think it should work. So we go to the module of SOF generator, upload the file. It gives you a very detailed overview that you would want, a factual summary and the timeline. Alright, I think there is some issue with playing videos on the presentation mode. So in the same way, I'll give you a very quick overview, and of course we are available around to give you a live demo as well. So after the generation of summary, the next module is how do we create head notes for a judgment. In the very same way, upload a document of the judgment that you would want to create a head note for. It takes a few seconds to process that and gives you a very detailed overview of the document, like a head note of the document, along with explaining what were the facts. So in this case, I uploaded a judgment which is around reopening of an income tax assessment under section 147. It gives you an overview that okay, this is the party, this is the issue involved, and what are the sections involved. It also gives you a detailed fact, a summary as well as a detailed fact of what the matter pertains to. In this case, it was reopening of a case after a new IT-80 judgment had came out, and which basically re-warranted the assessment under 147. You are able to extract the arguments of both the sides, the petitioners and the other party, the respondents, along with the reasoning. And this is where the important aspect is that if you use a generic AI model, it would never be able to explain you the legal reasoning which goes behind coming up with a judgment, right? So hearing both the sides, and then you eventually come that okay, this is how how I would arrive at the judgment. So those along with the citations. And if you would want that any specific information beyond what is already covered in the overview, that is where you can click on chat with the judgment and ask a specific query. So in this case, I asked a very simple query that okay, why this case was reopened, and then it would process the judgment, and it would come up that okay, this is reopened because there was a new IT-80 judgment which basically changed the matter of fact. Perfect. The last so I remember when I started my chartered accountancy journey, right, back in 2015, I joined a firm for articleship, and for the first 22 days, I was given a very simple task that one of my client was raided by the income tax authorities, and there was some statement that they made which were recorded in the Panchnama, and now they wanted that before the income tax settlement commission, is there a possibility that I can take a position that whatever was said in the Panchnama, it was under some sort of undue pressure, right? So we had to literally spend 22 days going through all the commentaries, Nani Palkhewala commentaries, various books and historical judgments which were there, but could not find anything. And after those 22 days, we realized that this could have been possible if there was some tool available or if there were better research tools available, right? Mostly at that time, 2015, the kind of judgment research platforms which were available would usually use keywords. And then keywords, I would say statement of oath, 100 in section, say 132 subsection 4. It would give all the judgments which are in favor or against. And then we had to literally go through each of those judgments to see that, okay, does it favor me or not? Now, versus comes today, right? I can very precisely ask and draft that, okay, this is the judgment, this is the point I specifically looking for, and is there a case which directly supports my position? If not, I quickly jump on to the next case. So, yeah. So I come to the legal research assistant. I can type a query. I can see the legal provisions or the relevant judgment precedents that I want to check. So in this case, I'll type a very simple query again of what are the tax implications for agricultural income in, say, Income Tax Act. I can see the provisions as well as I can find the judgments. So tax implication, income tax implications for agricultural income. Then click on legal provisions to first see understands the precedents which the legal provisions which are there. And it would again come up with a very detailed explanation of what provisions are, starting from the definition of what is an agricultural income, and then what are the tax treatments, and then how do we deal with it. So that gives you a very detailed step-by-step understanding, which, say, other solutions will not be able to do. Now, after I understand the provisions, I might want to find that, okay, let me also help get some help on finding the right precedents of the cases. So that is where the same query I can click on find judgments, and it would give me a match of what judgments are there. Now I click on find judgments. So more than 100 judgments have been found out for this particular legal problem statements, along with a quick summary, and then I can click to see the detailed judgments if I would want to. So this again, if for an enterprise data, like for a law firm, it can further be connected. So if your firm have a very specific positions about a certain matter, that, okay, maybe say for taxation of royalty, my firm would want to take these positions or rely on these judgments, that can also be incorporated here and right into the system, and that would also give you your firm's positions as well. So that these are the high level capabilities, I would say, right? While there was some trouble playing the videos, which I believe always happens on the larger screens, but I hope this gave you an idea of what are the overall capabilities, and what you see is not the end solutions, right? It is an engine on top of which we have used some daily, already built some tools for the daily workflows. If you would have a very specific problems, the ability to build an agent on top of it is very simple. Given that this is an audience looking for adopting AI, and all of us are forward-thinking leaders, I want to quickly summarize a legal AI framework, the 7 questions that everybody should be aware of when you think of implementing AI as a solutions. It starts with, first is legal task identification. What is your problem statement, which takes most amount of time, money, and efforts for you as an enterprise. Second is how, when you implement solutions, how are you going to take care of ethics and bias mitigations? Then comes the governance and the compliance part. How do we be compliant with the data privacy laws as well as the other security standards so that the confidential data doesn't go out? The next step would be change management, because the biggest fear when it comes to AI implementation is it going to take time? And the second would be, can I really trust the AI systems? Then how do you upskill your existing workforce to use this daily tool? How much to rely on, how much not to rely on? And the last 2 aspect is, how do we measure ROI of the implementations? And then how does the whole system integrates with your existing workflows? So that's pretty much, I would say, summarizes my presentation. We'll be around to take up further questions. Thank you so much.
Thank you, Hardik, for providing a comprehensive overview of AI in action demonstration. We are deeply privileged to now invite Shri R. Venkataramani, Attorney General of India, to share his insights. With decades of experience in constitutional law and public policy, Shri Venkataramani brings immense wisdom to questions of legal reform, access to justice, and regulatory innovation. His thoughts on how the Indian legal system can embrace AI without compromising rule of law will guide us as we shape the next phase of the Pallet Center's mission. May I now request Shri R. Venkatramani to kindly join me on stage for the guest of honor address.
Let me begin with some lighter notes. And because the early years of building a library, we were taught to collect books on English law. Holdsworth, History of English Law, Blackstone's commentaries. So you begin to stack your library with all those. A lawyer without those books is not held in high esteem. You go to good old barristers with their libraries you find in Allahabad, Calcutta, Madras. So these are the kind of books. So I started collecting many of them. But I think a couple of years ago, my library with the shelves along those books began to have a second stage in my reading list. And obviously, when Judge like Chief Justice Chandrachud was asking you to keep your printed papers and cyclostyle papers aside and look at the new emerging systems of interactions with human beings, there was no other option but to move towards literature and artificial intelligence. And to say my good part of my library today has a lot of books on artificial intelligence, not because I am young enough to understand and comprehend them, like many of you here, but the yearning of any mind, the inquiring mind, to look at whatever possible that a human beings can create to make the world a better place to live. I think all of us are looking for that. And I should congratulate Anshul and Bits Pilani. A few more personal anecdotes. Just after I finished my graduation in physics, I was trying to get into an engineering institute, and Bits Pilani was one of them. But I could not get my admission at that point of time. And never I did thought that at some point of time later, about 40, 50 years later, I'd be talking to the institution, hosting an important event like this. Thanks to Bits Pilani for calling me today. And talking about complexity, I think is our favorite engagement. Can you be goodbye to this pastime? Justice Chandrachud was talking about Babita Punia's case. I mean, to complete my lighter side anecdotes. So on one of those occasions when we had 2 or 3 cases where female officers were having very legitimate claims about promotional opportunities and careers in the armed forces. So I asked one of my juniors to peep into various judgments of Chief Justice Chandrachud and tell me what are the probabilities that I can probably have a case against his mind or thinking thought process. I did not get much answer in my favor. And what was that? It was through a ChatGPT process one of my juniors worked. But then I did not know about ChatGPT before that. And then it was at a time when the Attorney General has to do a lot of speech making in farewell, occasionally SCBA farewell and then welcoming judges. So I asked my same junior to get me some good, information data on a retiring judge. So he came with a 4-page printout on retiring judge. I said, no, this will not do. I think something better. Then I asked him, where did he get from? He said, ChatGPT. I said, no, I'm not going to do that. I'm going to do it my own way, where my mind understands what the judge has been. So I've done about more than 25 farewell speeches now, all of them through my own understanding of what a judge or a judgment means to a human being. By this I do not mean that we have no place in our universe of thinking for artificial intelligence. Having said that, one of the most intriguing subjects for a lawyer and a judge is truth discovery. How do you discover truth? you have hierarchy of courts. And then you find after 3 or 4 appellate processes, a trial court view is affirmed with the Supreme Court. Maybe a 5-judge bench after too many dialogues within the Supreme Court. I mean, how does it really happen that in the hierarchy of courts, truth discovery suffers either this multitude of views, and how does the truth discovery really happen? I think we are probably entering into a new understanding of how can we profitably discover truth without those too many casualties in the process of hierarchy of courts. I do not know whether artificial intelligence can help us in a big way in this process. If after all, truth discovery is fundamental to doing justice and nothing beyond that, and how do we articulate this new artificial intelligence engagement in truth discovery? That's where you talk about, I was reading books on sentencing in using artificial intelligence sentencing discretion. So we talk about bias, etc. I'm not going to talk about all that now, but I thought there are some of those areas where the new emerging machine age, with all its multiple facets and dimensions, can make human life better. If it can make human life better, then I think we vote in favor of that. So perhaps the palette created by Anshul is not a palette of M.F. Hussain or Picasso or Van Gogh. It's something very different. And I hope it's going to be very different in times to come. Having said that, I have some more very fundamental thoughts, a little away from the young dean was talking about, and the dean of deans, Chief Justice Chandrachud was talking about. Let me take your permission to reflect on these issues. From the motions towards placing all obligations and measures on state and governments, whether in the field of economics or in the field of justice, we are beginning to talk about decentralization. It would be an interesting search to connect all freedoms to freedom of the human capacity and the extent to satisfy or fulfill human needs. The idea of a free market is a limited edition of this free human capacity. In the very nature of understanding human creativity and the relentless drive for innovation, we realize that freedoms must be guided by freedom from within and the high ethical instincts and not by external dictations. It does not matter that a centralized authority as an enlightened political party can claim to possess non-partisan knowledge or ideals. It seems we have traveled rather deeply into this exciting world of all freedoms. Our journey has been made possible by the tools of technology. In contemporary times, the silicon chip has become the new gold, though as we are reminded that it is business models and data proliferation that have turned silicon into gold. If you are to talk about the journey from steel to silicon, we must talk about how the fate of nations now turns on their ability to harness computing power. Who can say they disagree with the thought that semiconductors have defined the world we live in and the structures of world economy? It is in the midst of these irreversible wheels of history that we are talking about artificial intelligence as a species of smart technologies. If business plays knowledge in the driving force behind this, we need to have some governing theory. As I said, our motions away from state-centric engagements are also motions towards decentralized autonomous organizations to occupy the role of governance measures. The role of law and justice dispensation systems will have to necessarily expose themselves to these changes. Otherwise, we will be mechanically pursuing the brick and mortar of worn-out strength. The adversarial system is already like the leaning tower of Pisa, leaning rapidly towards its failures. The idea of a Pallet Center is to be seen as one of the ideas to transform data and technology into justice delivery tools beyond business models. It is an ambitious idea. A technology university such as BITS, no doubt, can dream of becoming a laboratory of such an idea. If law schools must become R&D laboratories, they must do so going beyond serving mere trader commerce or conventional time and cost hungry systems. We need to create a compact of knowledge systems where law meets technology and technology informs law. From a knowledge focus on narrow, crowded corridors or preoccupation with adversarial system, we need to create a justice vision for the next 25 years, where the focus will not be on promoting, I repeat, on promoting ego centers of professional individuals. That's what we are today. Our bar is what we are today. So ego centers of professional individuals, but collectives of people in search of solutions to justice claims. Can we have a collective of people who can be partners in promoting solution to justice claims? We have different sections of community with the different justice needs. As long as equality is an elusive ideal, we will have the different justice needs. So the adversarial system perhaps cannot march ahead with the ever-increasing demands of justice need of different sections of the community. We don't have any model along the world where we can copy it mechanically, because I think every part of the world is suffering from the same ills and the same issues and challenges. Good, it is so, because somebody India can say, look here, we would probably occupy this unoccupied space which the world has not been able to occupy so far. So as we move into a demanding dialogues on technology and law, innovation and ethics, it appears we are called upon to open new thoughts on the frontiers of human condition itself in general. The human mind wears dual hats. It is both like a jumping monkey and a mediating saint. Not knowing and knowing. Who else but the legal fraternity entrusted with the task of articulating ethics through law is best fitted to work on knowing technology for the common good and the technology of human rights, where utilitarianism and altruism may merge, where accountabilities and enforcements may demand new institutions beyond courts and adversarial system. If Pallet can be one such compact, we welcome it with a great ovation, and certainly with the young minds around here, I would like to greatly applaud this innovation. Let me congratulate Pandey and Beats once again for engaging into this very, very demanding need of the Indian community. And probably, as I said in the beginning, 3 years ago when the Attorney General, somebody rightly said it's not going to displace lawyers, but somehow you have a lurking doubt about that in the lighter sense again. So perhaps instead of one Attorney General for India, every ministry, every department will have artificial intelligence centers who can deliver opinions for each ministry and department, so that we are only artificial intelligence generals of India instead of one Attorney General for India. So I suppose in that way the Attorney General will continue to be a position in the Constitution of India. So, but that's on the lighter side. But I think when I entered this position, I began to encounter this problem. So how do we really work on a foundation where the demands of ethics and accountability from a high office like this can be delivered with expedition and neutrality, and without being biased by, because all of us, I have a bias in favor of, for instance, when I began my career in the Supreme Court, I've done a lot of work for the deprived sections of the community, having been associated with the Free Legal Aid Center for more than 10 years. So I have a certain bias. I remember one of those cases where a sitting judge of the Supreme Court in the Narmada dispute, river dispute matter, one of the early cases. the appearing for the display sections, then the counsel for the state was saying that look at what the petitioners are interfering with the due process of what the government is trying to do. And there was a report given by a commission of inquiry appointed by the court. And they said, this is a biased report. The learned judge said, the bias was a right bias. And that's how it ought to be. So we're looking for right biases. But then who will sit in judgment over a bias is right or good or bad? So I do not know whether intelligence systems, such as artificial intelligence, can probably encounter, engage, and provide solution to this problem. They are very important concerns. So thank you for calling me here today. It's a great pleasure to listen to Chief Justice Chandrachud, as always. As I said, he's the Dean of Deans, and his court was always a classroom. He's not a teacher only now. So thank you for calling me again here, and I'm sure if there is an opening in this center for me to be registered as a student, I would like to welcome that. Thank you so much.
Thank you. Thank you, Sri R. Venkataramani, for your truly inspiring words. I now invite Dean Ashish Bharadwaj to felicitate D.Y. Chandrachud, former Chief Justice of India. May I now invite Dr. Anshul Pandey to felicitate Sri R. Venkataramani.
Very quick announcement. We'll take a 5-minute pause. If anyone wishes to step out for a cup of tea or grab one of the cookies, and we'll be back in 5 minutes to start this fascinating panel on law and AI. Do come back though.
I kindly request everybody to be seated as we start shortly.
Yeah, that's good. You can keep it there. We'll share these two. Yeah.
As we look ahead to a future where legal practice and judicial processes are increasingly shaped by intelligent technologies, the question we must ask is not just how AI will change the law, but whether it will augment human judgment or replace it. Panel 1, Law and AI Augmented or Artificial Intelligence, explores the philosophical, professional, and practical dimensions of AI in the legal field. May I now invite all the panelists to the stage. May I also invite our moderator, Dean Ashish Bhardwaj, on stage.
Brave panelists, please come to the stage. Vishwas, Tejal, Kashyap, Roshan, Dhirendra. I have to keep the energy level high because I see some of you are looking towards the exit door. Vishali, lock kar do. Okay. Thank you very much for staying back. We've planned two panels, and the idea is to share perspectives from different domains of the legal fraternity. Academia, perspectives from someone who works in an in-house legal team or a corporate firm, a law firm, someone who understands the industry, academia, bridge. So my expectation from this panel is that my speakers, my wonderful, illustrious thinkers sitting here will share some provocative remarks so that we could have a good discussion. So I have some questions to get us started. And I would request the panelists to keep their remarks brief so that we can run through maybe 2 rounds of questions. Actually, let me do a poll with the audience. How many of you, based on what you've heard from the speakers since morning, how many of you think that the currently available AI systems pose a serious concern on the idea of ethics or privacy or disruption of learning? How many of you think? Okay. 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 So there is some skepticism. All right. Okay. Okay. All right. So with this anecdotal empirical evidence that we saw, the title is is this technology supposed to augment the work of thinkers in this field, in this discipline, or it is simply artificial layering of what we already know? Dinendra, let me start with you, because you've helped unleash this monster. Can you pass this, Tejal? Can you pass the microphone? Oh, okay, thank you.
Hello. Yeah. Yeah. Good afternoon, everyone, and happy to take up that question. And obviously, I would say that at this moment, the way the technology is rapidly changing, you sometimes feel like that you are standing on a platform, and there are multiple bullet trains passing across the platform, and you don't know what to catch, and you have a fear that you might be left behind. And the fears are not completely unfounded. There are certain skepticism and certain valid reasons behind the same. But the story is not new. Actually, to be honest, right from printing press to anything that we are doing right now, anything that we change in technology or any progress that we make in the human history, it's always filled with certain skepticism. And my biggest worry is that sometimes people feel that the fear of the unknown will overpower the benefits of the known. And I would strongly urge everybody to always keep that in mind, that you should always try to reap the benefits and harvest the benefits of the known rather than being too skeptical about the fears of the unknown.
So is it really fear of the unknown? Because it is a known fear now. We understand that what it may do, which may not be really in the right domain. Is that something you were able to capture in your book, Kashyap?
Can you hear me? Yeah. So I wrote a book called AI for Lawyers, a short and happy guide to AI for lawyers. So the back of the book says what happens when the world's fastest moving technology meets the world's slowest moving profession. Okay. So we have to see this in the context, this question of fear, augment, eliminate. See, elimination is out of the question. So I sort of have a leg in the legal field as well as in the technology field and field management, etc. So from the outside in, looks like just like other professions, the legal profession also has some elements which can be automated by existing tools. And there are certain aspects which should not be automated. So we need to look at this debate in the context of what's happening in India, the larger context, if I may. So very briefly, about 2.5 crore cases are filed in India every year, and we are not able to clear them 100%. We have a backlog of about 5 crore cases. And then Dr. Ashish mentioned that the number of judges is about 15 per a million or 10 lakhs. So the Supreme Court says we should have about 19 or if the Supreme Court says we should have 50 judges per 10 lakhs. But even if all the vacancies are filled up, we have about 27,000 sanctioned positions in the judiciary, but about 21,000 are filled right now. So even if all of them are filled, we'll still have only 19 judges per 10 lakhs. So also, so we definitely need help in the form of responsible automated tools that can help us in the medium term to long term. So that's one aspect. The second aspect of where the fear is coming from is that there is probably about 20 lakh lawyers in India, and 70,000 lawyers join that pool every year. There are 1,700 colleges. I'm rounding up the numbers in the interest of time, but maybe less than 10 teach any kind of data science, any kind of automation, legal technology courses. So it's really that fear of the unknown. So big step, congrats to Anshul and BitsLaw as you do this first small step. Maybe it's that one small step for BitsLaw and PSI, but maybe a giant leap for the legal fraternity out here.
Or humankind. Why limit to legal fraternity?
Why not?
So I'll take it forward from here. You said the mingling of the fastest moving technology, which for all intents and purposes is becoming a general purpose technology, like electricity, pretty much. And it's blending with the slowest occupation. Because there are so many lawyers here, I'll rephrase that a little bit. We want to keep the relationship going. So I'll call it protocol heavy, skill intensive occupation. Better, right? So, but is that something that you're also seeing coming out in the classroom? Vishwas?
I will respond to that question in a bit. But let me actually kind of take everyone back to an observation made by the Supreme Court Chief Justice, John Roberts, in his annual, statement he made a statement primarily saying it's all good to be working with AI, but we need to kind of adopt a cautious approach and need to be a little more, humble. There needs to be more humility in kind of taking AI forward in its integration towards, how judiciary kind of works with it. And taking on that, a very interesting judgment written by a Federal Circuit judge, Kevin Newscomb. He very clearly kind of in his judgment declares that he used AI in his judgment and very clearly notes for what purpose he used that, AI to assist him. And he was actually troubled by a very interesting word, which is landscaping. It was an insurance case largely dealing with the question of whether trampoline is part of a landscaping element or not. And he said, he asked his assistant to understand the term, give a note on defining landscaping, both legal, dictionary. He felt it was a very unsatisfying exploration of the term itself. He spent about 3 hours doing it. And then he said, he then asked his assistant to actually go look up landscaping on any one of those LLMs, ChatGPT being one of them. And he said it threw up a very, very interesting perspective, not just of what the plain meaning of the word is, but rather the contextual element of it, right? And that is where he actually makes a very interesting observation that where AI tools can be a very useful element in the judiciary and for the legal fraternity. And he spots this thing, very interestingly says, it seems like AI is very good at picking up patterns, consistencies, inconsistencies. And he himself kind of goes back to his approach. He's a textualist, so he's more of an interpretativist. So who's primarily kind of very satisfied with the response that he actually gets from ChatGPT and realizes how to use it in the specific context of his judgment, right? He had 3 other judges actually writing on similar lines who didn't necessarily use the AI, but he clearly goes on in his verdict that he's made a declaration about its use, what it actually kind of enables him to do, and the limitations of it. In fact, he goes on to actually write 3 pages, right, in terms of, the good and the bad of using AI, the guardrails around that a judiciary needs to actually put in place in order to ensure there is more trust and faith in what the judiciary is doing by using AI. So that, I think, is a very, very useful tool, which can also be used in a classroom environment.
Finally came back to the question. Finally. But I'm not going to let go. I'm going to ask the same question. See, that's the problem with lawyers, and that to a law professor. It reminds me of a joke which famously in the 80s Mark Gallanter, a very accomplished law professor, said, "What do you make of 6,000 lawyers at the bottom of the sea?" And he said that, well, that would be a good start. I mean no offense. We come in peace. But Vishwas, the same question again. You talked about patterns, consistencies, inconsistencies. What kind of patterns and inconsistencies do you see in young lawyers or law students?
I think the danger that we will put them in is probably not make them realize what original thinking, analytical skill, in-depth research brings. I think a shortcut approach to embracing AI in law schools might actually throw up these results where no law firm, no lawyer would largely want to kind of have, someone who is trained in that way to actually engage, with the legal profession.
Thank you. Thanks. That brings me to Tejal. You're part of a very established, successful tech company. So the expectations from you as a panelist are the highest at this point in giving us some very conclusive responses to some questions. One of them is, do you think that this technology at this point in time is augmenting the work that you all do on a daily basis?
So let me just start with a resounding yes. Okay. So let me take this further. We are at the BlackBerry stage of AI. Okay. Unfortunately, the young law students or the young lawyers that come in have not seen BlackBerry. So they are trying to make this AI do things that it's not necessarily geared to do yet, but will do in a very short period of time. So one piece is that we're extensively using it, and which is why I love this combination with BITS and the law school and AI, because you have the perfect combination where a lot of the tools that we've built in-house, along with the lawyers. So that's one piece. I think the second piece is we are very, very intolerant of errors made by machines, whereas humans make errors all the time. And we are far more forgiving of that. So I think the way we see it is it all depends back on what you spoke. The purpose for which you use the AI is going to determine the risk you take.
Did you just equate machines with humans in a very subtle way?
I'm not sure I equated them.
Okay.
My sense here is that the reason that AI gets dangerous is because it works on scale. And therefore, the errors it can make are not individual in nature, but they can be, which have a much rather larger impact. But if you use AI with purpose, and the purpose is right, we found that almost 90 to 95% of our use cases are not high risk, but they are augmenting, they're increasing time, speed, efficiency, quality of the legal output. So I actually have a tool, for example, similar to Nyaay AI, which compares my contract clauses with standard clauses and tells my junior lawyers what they are missing. It just improves the quality of it. Now, my more experienced lawyers don't want to adopt that. So they say, no, we know better. But that's not true. Everybody can miss a step when they're reviewing a document. So in my sense, it's a big resounding yes, both on time and quality.
All right. Let me ask Roshan a question. Do you agree that we are at the BlackBerry stage of AI? And how are you, as one of the premier law firms of the country, dealing with this gale of creative destruction, as Schumpeter put it once?
I've never used a BlackBerry in my life, so let's begin at that. So I don't know what that stage looks like, but I imagine it's possibly T-1. So the radical statement that I want to put out possibly is, I think everyone here agrees that AI makes us do things. I want to lead with this possible argument, if I can, that it also makes me think. So my heuristic and the heuristic that my firm adopts when we think about adopting these tools is we think around 3 lines. We think around intuition, what creative outputs can we generate. We think around amnesia, what am I forgetting, right? And we think around sycophancy. So there's some literature on this that kind of sort of teaches us that AI can be a very good henchman. It can follow me better than it can follow the law, right? So if that becomes a reality, as a sycophant, how does it hallucinate? I can give you guys an example. Sometimes when I take the models available to me for a spin, I say, I'm thinking about solving this problem. Let's say I'm drafting a data sharing agreement. I want you to solve this problem through two lens. Lens 1, I'm solving this for a large company. Lens 2, I'm solving this for a small company. Tell me what's the difference going to be? And what I have observed with these systems is that they're designed to tell me to do more in case of the large company. And I realize that it's being a sycophant, because sometimes the law does not want me to do more. Sometimes it will say, well, you can think about localization for the large company. And I ask myself, does the privacy law want that? So that's the heuristic, the IAS model. And I think the I is the most important model as we race forward. How intuitive is AI? And to my mind, the creative questions that it is solving now are not legal questions. They're questions of commercial interest. How does it distinguish between bigness and smallness? How does it distinguish between prestige and the lack of prestige in a commercial context? And that's where we come from.
So I'll pick from there. You said something very interesting. AI is making you think. And there was this meme which got really popular that I want AI to not think and write for me, but do my laundry and dishes. So here's a question. If AI helps us think more, think better, and think deeper, then are we looking at a real scenario of the world being eventually divided into those who can write and those who absolutely cannot write well? Let's get a perspective from the technologist. Dhirendra, what do you think? Are we looking at this scenario, write and write nots?
So I'm an eternal optimist, and I always hold the human resilience and the adaptability in much higher esteem than what most people perceive it to be. I honestly feel that you should always make your computer do things that you hate doing yourself. And at this moment, with the advancements that we have made in the AI. So I've been in the industry, technology industry, for around 2.5 decades. And there has never been a more exciting time than it is right now. So at this moment, if you are not using AI, you are losing out on some like very, very remarkable efficiency in any profession. Now, there are obviously concerns that have often been raised that, okay, it hallucinates, etc. And precisely that's the question that started happening like 1.5 years ago. And we tackled that problem like right in the face. And we have solved that problem. So there are technical solutions. There are guardrails around everything that you're possibly doing with the world of AI. And I believe that even if you look at like electricity, there's always a chance that, okay, there can be a short circuit and there can be a fire, right? But does that stop us from using the electricity? No. How do we stop that? We build some guardrails around that. Similarly, even in the case of technology or like AI, you can build guardrails. Now, people generally have like a very limited understanding of what AI is currently capable of and what AI is doing. There are like extremes. So some people think that everything in AI is all about ChatGPT. No, it's not. It's just a small part of it. It's just a reflection. It's just like a representation of what AI is. You have to tune that model. It's like a horse. You have been given a very, very powerful horse, but you have to train that horse. Until you learn to tame it and train it, you cannot make good use of that horse. So that's exactly how I would draw an analogy to that. So that's really my honest perspective, that to think that we would stop thinking altogether, no, I don't think so. I think what would happen is that we will get rid of the time that we'll save, even for like specific to this use case about the utilizing AI in legal. Rifling through like thousands and pages of documents written across different vernacular languages and finding a specific piece of text, or like what is the technical term called Nazir, right? Why does a human mind need to waste time on that? Human mind can be better be utilized on something else. Now, again, one could argue that, okay, kids these days are copying essays from ChatGPT. But there are, again, tools which can actually help you detect whether there is plagiarism, whether there is something auto-generated from GPT. So there are guardrails around that. So the fears are there, but I would say they are kind of misplaced at this moment.
So I'll summarize it in a slightly different manner. It's a technologist's way of saying that if a teacher can be replaced with an AI, then you better replace that teacher with AI. Don't try to induce complementarities. Kashyap, did I get that right?
See, I think I just want to stick to writing for a minute. So there is this saying, right? They say that the pen is mightier than the sword. But now the prompt is mightier than the pen. So we're in that situation. I've written more than 1 million words in my career so far. But I have to admit defeat at some point in time. AI is doing a better job. So that's quite interesting. But if we zoom out, there is this concept that's coming called as cognitive cognitive offloading. So you stop thinking. And this we see in other professions as well. So like when you fly a plane, except for landing and takeoff, it's mostly run on autopilot. So the Pilots Association worries that the pilots don't know really, unless you're very experienced, how to manually fly the plane. So for a lot of thinking professions, white collar professions, law, finance, other things, if we are not careful, we may end up with that risk.
You said cognitive offloading.
So we're offloading our thinking to AI.
That reminds me of another word which a lot of behavioral scientists use, which is cognitive dissonance. That you stick to your guns no matter how resounding and convincing the argument is. Are the AI enthusiasts leaning towards this direction, Tejal?
That's clearly a challenge of AI. AI is like a good counsel arguing in our courts. Irrespective of whether they are right or wrong, they will try to prove that point. And so AI is doing really the same thing, and that's a big fear, because it will justify the content that it is generating. But we have to look at it in the context of what are we trying to improve. We as a country in India, we have a vast number of people who are not trained as well. We have a vast number of lawyers who are really not very competent. And so what AI can do is bring up the level of a vast majority of the profession to a level which is, of a particular standard. The other biggest kind of fear I have is not just the dissonance, but it's also, it takes more experience to find out what's wrong than to say, I don't know. So if AI generates something, it's very, very difficult for us to then pinpoint what it has actually said wrong in that sentence. And it takes very experienced lawyers to find that out. So there, I think we should be really clear, are we using it for the vast majority of the people to pull them up? Or are we using it, are very experienced lawyers using it to figure out what is right and what is wrong? So it's actually operating, I think, at two levels. But I'll just end with one more thing, which I just wanted to point out. Artificial diamonds were developed in 1954. And today we have governments who are saying that there is nothing like a lab grown and a real, it's all one and the same, right? It takes time, and it is going to bring up things to a particular level. We'll just have to figure out AI to solve AI problems, to your point. If AI finds plagiarism, then AI will find non-originality, then AI will find errors. Because a human mind is not going to be able to do the scale.
But why not? Why not? So let's take a step back. If it's difficult for an astute judge to write a solid judgment which reads very well, if it's difficult for a professor to write a journal article which advances the frontier of knowledge, or a new book which brings a new idea, why should it be easy for learners to learn it? If it's difficult for me to write it, why should it be easy for someone else to learn it? It's the process of learning that you scratch your head when you face a problem and you realize that you need some more time, let the idea marinate in your head, and a quick answer is not the best way forward.
I would leave that to the professors. It's a whole new generation who wants instant gratification.
That's you, Vishwas.
More than happy, but professors are getting sued in US for chat GPT PPTs, and class content. We want to go in that, way. So it's always kind of tempting to go for a quick response. But I think if you are looking at training young minds, I think first principles, understanding of, plain simple law is absolute, and anything that AI does supplements their learning. That's the way I would actually put it.
Okay. I have one question which I've written down, which I'm going to, it's like a rapid fire. So if you can answer it in one sentence, that'll be great.
If you're expecting a rapid response from a lawyer, probably not.
No, no, try. That's what, it's important to push the boundaries of comfort and convenience so that good ideas come out. In your understanding and experience, we'll go from that corner and we'll come towards Vishwas. In your understanding, your own experience, your own beliefs, your own optimism, although we are a country that disappoints the most optimist and the pessimist at the same time, what is the one existential threat? I know as a CTO it's difficult for you to point out this one, but try. One existential threat and one undisputed strength of using AI in delivery of justice. Mike.
Yeah, so my biggest fear is really the fear of the unknown, like preventing us from moving forward. That's really my biggest fear. And what I would say the biggest strength is really the ability of artificial intelligence to do lot of data scanning, extraction, and lot of other things that can be really like saving lot of precious human time. And the scale at which AI can do it, I think it's simply unmatched. So that's the biggest strength.
Thank you, Dhirendra. Roshal.
I have very similar thoughts. I think the undeniable strength is a zero draft. Right now, I think we can do a zero draft of virtually anything in the legal space with AI. What I'm afraid of most possibly is amnesia. I don't know what I have forgotten thanks to AI. I know that it makes me think about certain problems in certain ways. I think there are some scholars who will talk to you about Brussels effect and how countries are adopting other countries as models. I feel that maybe tomorrow the way I think about privacy will be largely like the EU, or the way I think about antitrust will be largely like the US. So that's my big fear.
And strength?
Zero drafts.
Oh, zero draft. Okay. Kashyap.
So thank you. And I think the biggest opportunity is access to legal knowledge. When you go to a doctor right now, for you or for your somebody in the family, you Google all the symptoms and you sort of know better than the doctor when you go to the doctor. But the same thing doesn't happen with legal knowledge. It's not democratized yet. So now we have tools and technologies which let that happen. That's the biggest opportunity. SDG 16, 16.3, access to justice. First step is access to legal knowledge, democratize it. The threat again, I mean, this will play to the sweet spot of Pallet, which is the law profession is such that you need to learn lifelong. You need to be original lifelong learners or lawyers. But in that suite of what they're learning, there is no technology. We don't have continuing legal education credits or requirements in India, but it's there. It's the norm across US, UK, and other countries. Even in India, the CAs and the doctors, they have CLE requirements, continuing legal education requirements, but we don't have that. So if we, for most of the lawyers in this room, probably not in this room, but in general, AI is a black box. So using tools that we don't know anything about is a problem. Right now, for the big law firms particularly, ignorance of the law is not an excuse, but ignorance of AI is actually lucrative. We can bill more. So that's the challenge.
Teja?
So, you know, from a corporate perspective, what corporates really need is speed and predictability. And believe it or not, they will also need cost savings. So I think the biggest strength here for our country will be if we can build predictability, speed, and a consequence reduction in cost, because our legal delivery system has become dysfunctional in some sense because it is not available to everybody in a timely and a cost-effective way. So AI can definitely help in that direction. If I look at the challenge, I think the challenge is a change in mindset. Lawyers think in Word. We don't think in Excel. We don't even think in data or trends. So I think the mindset change to adopt something like this is the biggest challenge today. It's not the technology, it's the way we think about it.
Really like that example. It was a confession. Vishwas?
If you're speaking more specifically from the point of view of profession and law schools and judiciary, I think one of the biggest challenges would be the data on which AI is trained. There are bigger concerns, especially about India, authenticity of the data, and that might actually lead us in a very different direction. Strength is absolutely, in terms of pattern spotting, ability to kind of very quickly kind of, identify patterns and inconsistencies, which might help both lawyers, judges, and to an extent, students as well.
All right. So this is all the time we had. Because of paucity of time, we cannot take questions from the audience. We have another very exciting panel lined up. I'll sum up the conversation we had with a very interesting anecdote I heard in one of the conferences I attended. It was, and because my parents both taught at a university level, it resonated with me. And it goes as, a teacher is, both parents, they're going to teach in a school or a junior college, and the kid asks them, Mom, Dad, what are you going to do? Mom says, I'm going to teach how to draw, fine arts teacher. Dad says, I'm going to teach them how to understand law. And the kid, very young, responded by saying, when did they forget? Let that thought marinate in your head for a little bit. When did we forget some of the things that we are grappling with? On that note, can we have a big round of applause for all the panelists here? Thank you so much for your time. We'll take a quick group picture. Yes. One round of applause for the wonderful moderation of this panel.
Thank you all for making this session so rich with insight and substance. The second panel, AI in Legal Workplace, Risk or Revolution, addresses one of the most pressing concerns in the profession today: how AI is changing the structure, speed, sensitivity of legal work. Is AI a threat to traditional legal roles, or is it an opportunity to reinvent them? How should law firms and corporate legal departments prepare for this shift? And what does the next generation of legal talent need to thrive in tech-augmented workplace? To answer these questions, we have with us a panel of distinguished professionals who are actively shaping the future of legal work. May I now request all the panelists to please join me on the stage. May I also request Dr. Pandey for moderation.
Where is Ashish? Oh, there you are. Once you raise the bar this high, I'm just thinking how much less I can disappoint. So, my God, the bar has been raised way too high. Thank you so much, guys. I think it's between this session and the lunch that's where we are sandwiched. But we'll try to keep it light. There are a couple of questions, even though the topic is a little contentious, which is risk or revolution in AI. So there are a few questions that we were just thinking about while all the discussions had happened in the last hour or so. Let's just start with your initial take. I mean, this is a very broad question. How do you really right now perceive this space of new models coming in? They are almost becoming inevitable that you have to adopt them. The concerns are very legit. The known unknowns are kind of getting known. And the risks are also becoming more obvious. So maybe we'll start with you, Manjari, if you can give some initial thoughts.
No, I think just as everyone else before us has been talking about, and we heard Justice Chandrachud and Mr. Venkatramani, I think AI and automation are some things that we have to understand and learn to adapt to and adopt. You can't wish them away. They are here to stay. They're only going to become more finer and more astute as we go forward. The thing is that especially in the legal profession, we are so used to doing things in a particular manner that to try and wrap your mind space around something which can add value to you in certain ways is not the foremost thing on your mind. You know, it takes you time to understand that this is something that can actually make your life more productive, can provide value addition in certain areas. I personally, and in my team, and I have a young lawyer from the team here, and she's leading the whole project for us on technology and adoption of AI, is because I thought we should learn from them to see what is it that we can do to bring about this balance of, having these new tools which can enable us, which can add to speed, productivity. And I come from a Japanese company, so there is a whole concept which Japanese have for a very long time called Shosho Ketan B, which actually boils down to doing things. Your products need to be, or whatever you do needs to be smarter, fewer, smaller, beautiful. So it's all about productivity, it's all about agility, it's all about flexibility. And I think that's what AI does. So I think we are in a space where we are trying to see how best we can marry the two.
I'd actually echo whatever Manjari said. And, in terms of its impact, I'd like to think of what the American computer scientist Mark Weiser said about great technology. Great technology is like a computer that's invisible and quiet and lies in the background. That is how I would like to see AI evolve. As far as our own profession is concerned, I think in the short term, its impact is overestimated, and in the long term, its impact is underestimated.
Thank you. I actually think that when you think of risk and revolution as a dichotomy, it may be incorrect, because every revolution carries risk with it. And I think the one that we face as practitioners here is that we discard what has worked so far. And I think there's been a lot of reference to first principles, being able to practice the law a certain way. And I think those are, in the short term, essential tools that we maintain. We continue to learn first principles as the law changes as those principles evolve, because it lets you interrogate the results that are coming out of AI. It makes sure that you know how to use it effectively. Your answers are going to be better, your prompts are going to be better, what you're looking for, what you can get out of it, all of that is driven fundamentally by what we already know about the profession. And to build on what Manjari said is that, are you using AI to make those answers, apply those principles in a way that is faster, smarter, better, more, and ultimately, hopefully, more beautiful for your client?
Hi, good afternoon, everyone. I'm extremely bullish on AI. I think AI is going to have a fundamental impact on legal profession. I'm extremely bullish. I think I don't know about the risk. I think every step has got risks, like what Madhav has said. And I think I agree with what Hemant and Manjari have said before me, and I don't want to add to that. But I think I definitely come under the eternal optimist and revolutionary mindset. But I think at least what we have dabbled with at our firm and what I have been reading over the last few years and seeing things, I think there's definitely much greater thought and acceptance that AI will revolutionize the legal profession.
Hi. So the initial thought that is about AI is we don't know the known and the unknown. But the fact that this transformation is not just technological, it's cultural. For instance, Dr. Venkatramani spoke about when he started the profession, he had those books from Oxford, Black's Law. Then the shift came, we started shifting from using books as for research tools to SEC Manu Patra. Then later on, these tools are now evolving, and this is a transformation that we need to look at it as a culture, that the culture will change as a lawyer, how we practice, it will change. How, we are yet to see. We've just seen snippets of AI in the judgments that we've seen from US courts as well as Punjab Haryana court, which we just talked about, but it will change. So that's the initial thought that I have. There are risks.
Sure. No, I think there are a couple of things that do resonate really strongly with some of the follow-up questions. One, you highlighted being eternal optimist with regards to, and also how Attorney General had mentioned about upskilling and reskilling himself as well. How do you think about the reskilling of or upskilling of the more senior staff in your team? The ones who are maybe more used to the existing processes, at the same time empowering the younger, newer members of your team who are bringing all these new toolkits, and how it's really balancing both the skilling as well as giving them the stage where they can impart changes in the processes as well. So maybe Hemant, we can start with you.
Sure. I think it's really all about, in the initial period, leaving folks with no choice but to use the technology, to be honest, right? Because to be very frank, and this has already been said as part of the earlier panel about us being the slowest moving profession, and just to add to that, I think the last major technological change that we as corporate lawyers were perhaps a part of was when track changes got introduced by Microsoft Word. So I think it is going to be quite a radical shift. We are considering a variety of strategies, to ensure that the more senior folks can start embracing it. I think you have to really, to incentivize folks at the more senior levels to really start using it, you will have to ensure that you speak in a language that clearly shows what will be the immediate return on investment as well, because a lot of the law firm models are really built around the billable hour and the revenue targets and so on. So it's very important to ensure that when you're talking about the cost that they would have to bear when they're embracing the tool, how they would perhaps be able to pass on some of that cost to their clients, and what might be the differentiator they might be able to integrate into their service delivery, which will help them retain clients who are looking for differentiation in services that are being offered.
I think the key consideration for senior folks seems to be that the other shoe has dropped. The expectation from clients is that you're using it to augment your services, to be more efficient when you're delivering your services. You're seeing that competitors are putting in their engagement letters that certain tasks used to take us X number of hours, now takes us this many minutes. So when all of that has happened, I don't think there's a choice, and people are moving with that change. And at least for what I've seen and what we've seen in the firm with the tools that we've managed to build in-house, some of the best results that you're getting are from senior folks. And I think this goes back to my earlier point that when you know what you're looking for, when you know what you're doing and how to use experience, and what you really skilled professionals know how to get really good answers, and adapting that onto the tools has not been the challenge. But that cultural point that Rahul made, that once you culturally accept that it is necessary, the other shoe has dropped, you're getting outstanding results from very senior professionals using the technology.
So just on that, right, because I think this is a concern that even as technologists, we are hearing, like, how are you really pricing the tool, or how are you really thinking about it getting integrated in our own billable models? Just like managing client expectations, like your clients definitely are also aware that you are utilizing some of these tools, right? And there was a mention of a renegotiation conversations happening, right? So how is it really changing largely the billable hours in the revenue model, if you want to?
You know, I was just thinking when we were talking about the fact that, you know, you'll have to pass some of the cost on to your client, and I was kind of thinking from a very different perspective that if the client knows that you're using certain technology which is helping you to do the same thing faster, how come your billable hours go up? So they actually need to reduce, you know, to that extent. And so there is going to be this, I fully appreciate, and I've worked in a law firm myself, so I absolutely know that if you're investing in this technology and tools, there has to be a return on investment in some form, and obviously in a law firm that comes from your client. But to see and say how that value add is going to come, or which is going to be far greater than what it was earlier, in terms of when you were doing it quite manually and, you know, using the regular traditional way of doing it. So I think this conversation will need to be had. I'm sure there will be many more conversations, but it will also, to the flip side is that even as clients, I mean, when I look at our organization, we are also going to get more savvy at this, you know, and gradually the way of, it's how you are placed on that same platform of AI and technology, both at the in-house and both at a law firm level, where certain things we all understand, and the understanding of this is going to help the client law firm relationship in a more smooth, better way, whether it is billable hours or the kind of product that you're going to be getting from them.
Badri, same question for you. And like, do clients also then would require a disclosure of sorts, like what tools are you using? Or
definitely, I think clients should be disclosed this information. I think there are going to be proprietary tools and there are going to be non-proprietary tools. For example, what you take on subscription and then to do it. For example, today I'm sure the clients know that we use Microsoft Word, Excel and PowerPoint. But I think over time, I think we will have other tools also which will be doing that. I also feel that I think today, for example, all tasks that we perform for a client have the same billable rate. So if Badri is doing a work for Manjari, which is a 1 lakh matter, a 1 crore matter, a 10 crore matter, or a 100 crore matter, Badri's billable rate remains same for Manjari. Okay, and Manjari is very nice to pay that billable rate to Badri. But I think what will happen is that as we adopt AI, I think there'll be new pricing models and guidelines which will come in. So for example, a 10 crore matter or a 100 crore matter for Badri will still take more time and there'll be more billable work which will be there. But a 1 lakh matter or a 10 crore or 1 crore matter might actually be a subscription model of sorts for Manjari. So I think there will be some level of discussion between the firms and the clients will be on how do we manage these tasks which are of different complexities, but preferably overseen by a same level of category, because ultimately you're trying to manage the risk, right? As an in-house counsel, yes, what you're really trying to manage is risk. And you, at the same time, you also want to manage what's the spectrum of fee that you want to pay for managing that risk. And I think that's where some very interesting stuff I think will come up over the next few years in how we manage that relationship between a law firm and a client.
So again, it stems from the fact, what are we using AI for? Purpose, the purpose that we are using AI for, the tasks that we are looking at. Secondly, the confidentiality of what we are using the AI for is of utmost importance. For instance, if a senior member adopts it, a junior member does not know at the beginning of his career that a data breach of a client has vast problems for a law firm. For instance, a data is uploaded on a ChatGPT. For instance, my client is Suzuki. My junior puts up a statement of facts and put it on ChatGPT to what it does is to summarize. Now ChatGPT has that information. That's a sensitive information. At times we do SEBI matters. So price sensitive, M&A. There are a lot of things which depends on sensitivity of the data that needs to be looked at. The ethics will have to be seen. Third aspect when we look at is strategy and critical thinking. What a lawyer brings is value. For instance, we brief senior advocates. You've seen the Mr. Venkatramani, Dr. Singhvi, the value he brings. Will that change with AI? No. It will help him, but will it change or not is separate. Secondly, the other aspect that we're looking at is tools that we are adopting day by day. For instance, Microsoft Word. Now it also has Copilot. Now for litigation, we've started adopting liquid text. That helps us. The subscription model helps us. That's an investment that firm has made. So these are the kind of initiatives and changes that the firm needs to take, and then we'll have to see how it progresses.
Understood. Just on that, because how do you also then envision, Badri, the competition in this space? Because now I believe even smaller boutique law firms could be a lot more efficient. The quality of the output they generate would be a lot higher. So do you see like even the competition evolving significantly?
Absolutely. I was recently talking to a very senior IP practitioner from the US who's been practicing for about 20-25 years now. Okay, and we recently met up, and what he said is that he's a part of a very big law firm there in the US, but he feels that the tools are making the practice of law a lot more flat, just like the world is flat by that Friedman had kind of come up with. He says that the law profession is becoming more flat because you have tools now which will develop over the next few years, which is going to allow a person who's an individual to have a combination of agents, tools, and information for the purpose of being able to deliver a certain type of output, which traditionally large law firms with large number of people used to do. Okay, and that's really where it's going to revolutionize, which means that individuals today will probably have more power to be able to practice law, and that will change, and that's the good thing according to me. And I think the fact that you're going to have lot more democratization of the legal profession in terms of having a wider range of people have the ability to pull information together and provide, I think will generally in the end do well for the profession than the other way around.
So just extending on that, Hemant, now just the disclosure part, right? So just combining that, right? First on the competition, and then on the disclosures, right? Disclosures of, for example, we mentioned Microsoft Word or their OneDrive services possibly being used. There we are essentially sharing the data. So are the disclosures then going to be not just what tools we use, but maybe the data being shared on OneDrive, which was perfectly fine up until now? Then is it not fine that the data is shared with ChatGPT or DeepSeek to PRC? So just thoughts on that.
Yeah, so great question. And to be honest, you know, we've already been grappling with these questions for a long time now, and having adopted, you know, a firm-wide AI system, we very frequently answer questions from clients on exactly what the data flows are. Is the data leaving Indian cloud servers? Is any of their confidential data being input, naturally not into any AI system that we use? So there are, of course, again, you know, clients of all kinds, and, you know, we have clients who say that, look, we want, you know, this work done at a much faster pace, and potentially at a better price point, because, you know, by your own disclosure, you use AI for it. And the important thing for us as a firm is to be absolutely transparent that, yes, absolutely, if there is something that we can do faster, we'd be happy to, you know, pass on the benefit of that to the client. But at the same time, the way it's actually panning out is that there is high risk and low volume work, which continues to have a very time spent based, you know, billing model. And then there is, you know, low risk, high volume type work that clients are going to start turn to law firms less and less for, which will definitely have to steer away from a time spent based model of billing.
Understood. So the very last question, because we did talk about budgets and like billing hours and how is it going to be passed on to the client. So Manjari, first for you, this question, is there already enough credit built on the need to adopt AI models that budgets are being allocated separately for, because end of the day adoptions generally come from the allocated budgets for any new type of technology. Do you think we are already at that stage where it's no longer just experimentation, but defined budgets?
I think we are fast approaching it. I can say that for our own organization, that we have now a digital enterprise vertical. That I was sitting on a review of that just 2 days ago, and it was absolutely heartening to see that the kind of projects that they are looking at to have. We are looking at something called Tensai, which is an in-house built tool that we are looking at. So budgets are there. It's of course lies with the vertical. They are the service department, we are the user, and therefore if we want some things done from them and we have a list of projects which get approved starting day one, the budgets of that are now getting inbuilt. Of course you have to show the value to it. I mean, it really should bring about a value to the vertical as well as to the organization. But yes, there is already a discussion and talk around those things. Yeah.
Rahul, like just specifically, right, is the credit enough built that there is already defined budgets, or are we getting there?
We are still getting there. There are not predefined budgets as of now, because it again stems from the fact, are we culturally adopting it, or are we resisting it? And also it also depends on the kind of practice that we are looking at for adoption of this kind of technology. Is it disputes or commercial transaction? So therefore the value an AI would bring to a transaction or a litigation is something that will make or break a budget for a law firm.
Patri? I just want to go like across the table, because
I think there should be in every organization, including law firm, because law firms we hate because profit is the most important and the only thing that we all think about morning, evening, night. I can be very, very this thing, cash flow and profit. Yeah, absolutely. I mean, these are all universal truths, as you put it. Huh? But I feel that every organization, big and small, should have a certain amount of discretionary spends. The problem that we sometimes have with budgets is that we typically tend to have an outcome attached to it. And many times you will find some very interesting things that when we attach an outcome-based budget to experimental tasks, you typically only end up with disappointment. So instead what I would suggest is that if you have some amount of discretionary budget, which is just to be what in the startup space, that you just have to burn, okay? And you'd be amazed to see some very interesting things which come out of it, because you do end up seeing results which you don't anticipate. And I think I would recommend, I I have an uphill battle all the time in my organization to get these discretionary budgets, and I think, but wherever we have been able to get it and utilize it, we have only seen the benefit, not in the way that we envisaged, but in other ways. Okay, as they say, God moves in mysterious ways, and I think so does technology and AI.
Mother?
Thank you. But I think when you think about budgets for AI in law, in the context of law firms, I think you really need to think about it the same way you do, like Badri said, as an R&D budget. We're seeing constant experimentation, where our tool has changed in the short time since it's been rolled out to the whole firm massively. I feel like every 2 weeks we get an announcement that there's another feature. But those seem still relatively like smaller steps. We're seeing tools being rolled out by, really boutique practices. There's a firm I mean, it's a large international arbitration firm, but still quite boutique, that has a cross-examination tool that trains their lawyers how to cross-examine this particular witness, what is they put out in the world, what they're writing, what their leanings look like. Now that, incredible. These are sorts of applications are only going to come from experimentation.
Understood.
And becoming more and more key to practice. So yes, you need the budget.
Yeah, I think it's really not an option, it's not a choice, because, I don't think the day is very far off where, each law firm, at least to justify the fact that it's a large law firm, with multiple practices and so on, is going to have to deploy multi-agent orchestrators, which have specialized training data on which they've been trained and fine-tuned for. And to get there, I mean, you have to start somewhere, and nothing really gets started without that check being signed, I guess.
Yeah, I think then AI is definitely going to revolutionize at least the P&L. The cost center. This is great. Just one quick one-liner thoughts just for the young professionals, because folks who are still students, the law students, as they are looking up to all these large law firms, right? If you had to just advise, should they be jumping on this AI bandwagon right now, or wait for it, or like any words of wisdom? Just quick ones so that we can record it.
They certainly should address the bandwagon, look at it carefully, decide when to jump on it, totally or in a very balanced way. I would always advise the young law students or young lawyers that, do not lose sight of core law. That's very, very important. Your understanding as a professional of the law is very critical, but you cannot completely disregard the revolution that is happening in terms of AI and innovation, and you should be able to have that judgment as you evolve, to be able to marry the two, to be able to provide best solutions to your in-house stakeholders or your clients.
Yeah, so I think the sort of terse one-line response to that would be that the best way to future-proof your career would be to be prepared for a job market where jobs don't exist. Instead, the question should be framed as what is the value you want to offer. Because the basic structures that create need for legal service will continue to exist. Businesses will need risk mitigation. Large swathes of society will need justice delivery. There is going to be interpretative tension between tax authorities and taxpayers. So unless these structures go away, there is always going to be need for legal service. So the way to really frame the question is, therefore, how can you offer value? Rather than, try and build your life towards jobs as they exist now.
Makes sense.
I think as you're starting out in the profession, you need to think about two things when you're addressing AI. The first is, what does AI add to your skill set? But I think the more important questions in many ways is what are you adding to AI? Because as your clients will increasingly be able to get the same product, particularly in large sophisticated organizations, get the same product out of AI, if you're not adding anything onto that, if you're not adding nuance, if you're not adding quality, if you're not adding just additional arguments, if you're a litigator, commercial sensitivities, if you're a transactional lawyer, you're not giving value. And if you're not giving value, you don't have a place in that world. So if you just jump on the AI bandwagon and say that I can provide all services using this, and you're not something beyond your ability to use that tool, you're really doing yourself a disservice.
I think my one line would be I agree with Manjri. And my second line, if I may, is to say that the only advice that I keep giving young lawyers, and I will continue to keep giving young lawyers, to keep reading. And I think over time, you're always going to be on top of an AI system. And end of the day, we are going to live in a human versus human interaction based society, where as lawyers, we don't sell analysis, we sell a judgment, an opinion, a view, okay? I find far too often now lawyers tell, this is also possible, that's also possible, without really being able to say, I think this is my view. And I think the only advice, and this is the universal advice, will continue to be there, would be to say, keep reading.
If I just might add just to what Badri said, and I keep saying this to all the people on my team, that, we've forgotten to read. And reading means, I tell them, at least begin with the 2 national dailies of reading your newspapers. You have to have a holistic view of life to be able to provide an opinion. It is just not about people think that if you only just read the law, you'll be able to get. The law is in context of a larger ecosystem. So therefore, to understand your ecosystem is very, very important. So to be able to integrate the 2.
I recently had a general counsel who had come up with who said that I'm going to now prepare for a litigation in Supreme Court using AI tool that he's developed. I said, all the very best. Okay. So we had a situation where we were arguing this matter, and middle of it, suddenly he pulls out a thing that this is what the AI is now telling, this is how it is, this is what you must argue. I mean, impressive at a certain level, but then when you read it, it's contrary to what you really want to argue at some level. So, so I said that all this is very nice, but I think we need to read the law. He says, after Badri, after this AI and all comes now, no reading at all. At that moment, I felt safe. Because 99% of people are going to think, अभी कुछ पढ़ने की ज़रूरत नहीं है, टक करके डालेंगे और करके निकले आएगा करके, तो नहीं होता है वो, okay? And the last thing also I keep saying is that the most difficult thing in the legal profession is to read the law. Yes. Everything else is very easy. Invoicing is easy, billing is easy, business development is easy, putting out newsletter is easy, everything is easy. 50-page judgment of the law of the Supreme Court and to figure out what exactly it says is the most difficult task. And I think if we all focus on the difficult tasks, I think the easy tasks will follow.
Rahul? So I would just say that what Manjri said at the beginning, that you have to read. And for instance, my senior, every time he interviews, his first question is, do you need a newspaper or not? And that's the first conversation that he has with a candidate. That, do you read a newspaper? If the candidate says, I'm just doing a digital, I do read it at times, he loses his interest there, straight. So reading a newspaper, reading a judgment, what a judge thought while he was writing a judgment is premised on certain facts, certain circumstances, which I think is something that you can't get out of an AI. You may be able to fetch a judgment, but you still have to read the critical thinking the judge has applied while setting the tone, everything, because it's a story that he's telling. Until you read it, you'll not be able to understand where it started, where it ended, and that's what law teaches you. So that's my take.
That's great. Thank you so much, my fellow panelists. This was great. One of the things that happens with me all the time, anytime I get very consumed in the conversation, I forget like what the time check was. And but on the reading, because we have been talking about it, I think you would be very pleasantly surprised. There's lots of reading component that you will get from Pallet with regards to a bunch of things that we are planning out. So I think we'll make sure that there's no lack of innovative stuff to read about, for sure. Thank you so much. Thank you. Yes, we have. Shall we first get the picture?
Yeah. First a group photo, please.
See the perks of having a small step here. Thank you for it. Thank you so much. I can also step down.
Thank you so much. So I'll not, I think we'll part for lunch now. Right? Closing remarks. Oh, yes. Oh, there's Swapnil. Before we go to closing remarks, I do want to highlight one quick thing. The operations team that has put it all together. I know it's going to be covered in the closing remarks, but from Ashish and me, because we were talking about it, Simran, Rushali, we have Swapnil, we have Tanisha. They've done an incredible amount of work to put it all together. So thank you so much.
Thank you all for an enriching session. As we draw this landmark occasion to a close, I'm delighted to invite a very special guest to share his reflections. Mr. Swapnil Srivastava is the Chief Business Officer at PanScience Innovations, where he leads business growth and strategic initiatives focused on AI-driven transformation. An alumnus of BITS Pilani, Swapnil combines innovation and leadership to drive PanScience's mission. May I now request Mr. Swapnil to please join me on the stage.
All right, I'm not going to hold you long from lunch, but just on a lighter note, you said that reading newspaper is a criteria in the interviews. Let's add Pallet to that as well. Have you read things from Pallet? All right. So good afternoon, esteemed guests. On behalf of PanScience Innovations, Nyaay AI, BITS Law School, it's my honor to extend our deepest gratitude to each one of you for gracing the launch of Pallet and making it a resounding success. We are especially indebted to our revered dignitaries, Honorable Justice Chandrachud, Sri R. Venkatramani, Justice Indra Banerjee, members from the leading law firms, GCs, and also especially to Mr. Akhil Prasad from GCAI to actually help us put the show, and members from government and academia, whose presence and insights have added immense gravitas to this launch event. From the panel discussions and the keynotes, it's actually very clear that AI is required for legal transformation, and everyone is almost bullish about it. Okay, and this is not an idea of imagination. It is right now required on an urgent basis. As a result, an initiative like Pallet is coming at the right time to actually further improve the adoption of AI in the entire legal system. AI has immense potential to transform the process of legal section, making it more accessible, more optimized, and more efficient, and Pallet will play a very important role. As Honorable Justice Chandrachud said, AI requires a fundamental mindset shift and also capacity building for it to get integrated into our legal systems. Very happy to know that the idea with which Anshul started and reimagined the journey of transforming legal systems from Manhattan is now finally launched. So congratulations, Anshul, for that. Just wanted to share that the day we started Nyaay, that day itself we were very clear that we're going to have a center of excellence that will actually further the impact of these technological transformations in the Indian legal system. And the center of excellence will bring together people from diverse backgrounds, different stakeholders, bring those ideas, push the adoptions of tools through sandboxes, give you a lot of literature and a lot of support in capacity building. And that's where Pallet actually plays. Okay, so I would invite you all to visit our Mumbai campus and experience the transformation live. It's already there. It's real estate. We are not talking about a simple digital logo. All right. Until the last 2 years, as Justice Chandrachud said, we work relentlessly with different stakeholders in the legal system to shape the product that we have. Our product is of no use unless it actually solves for real world complexities, tackles all those nuances that lawyers, general counsels, everyone faces on a daily basis. So all those things have actually incorporated, and the moment you kind of adopt these tools, it will actually start showing real impact. With the caveat that there is a lot of protection that we thought around data privacy, data sovereignty, in order to not to jeopardize any of us, right? Be it legal firms or GCs. So those assurances have been built, and on top of that, you have the trust and technological expertise of BITS planning actually coming into the play and taking it ahead, right? Along with PanScience partnership. The pace of innovation is very fast. Almost every day you would actually come to know a new tool being built up, right? You would know about its features and all, but the guidance and the best practice that we would like to announce from this stage is that let that job of innovation and technical development rest to the experts, okay? Because those experts are gonna make use of every nuances that we face in the daily operations. All the use cases that actually required to actually transform legal systems, those have been built, right? And that's where BITS Law, PanScience innovation comes into play as the real experts to actually enable AI-enabled transformation in the landscape of Indian judicial system. Okay. Now, today marks the beginning and the launch of Pallet Center, but the success of any mission rests on the execution of its vision. All right. So that's where I'm looking at each one of you. Continue to collaborate with us. Continue to partner and engage with us. We are in Mumbai. Very soon we'll be there in other cities as well. But what I'm saying is that this is the founding cohort of Pallet. Okay. So let's continue to have this momentum in place because we have a very diverse representation from different sectors and aspects of the legal system. So I really invite you to experience the benefits of Pallet and actually propagate its mission within your organizations. Okay. As we move forward, very soon each one of you will receive a communication on our objectives, our events, our calendars, and our core activities, okay, which will really keep you engaged as we move forward with this mission. Now, towards the end, I will not hold you for lunch, but there is an exciting lunch lined up outside, which is gonna suit your palate. So that's it from our side, and thank you for being here.